I'd like to call to order this meeting of the Veterinary Medical Board and establish a quorum, so if we can have a roll call.
Ms. Bowler? Here. Dr. Bradbury? Here. Ms. Laredo? Here. Dr. Nunez?
The last man standing is here.
Dancing. Dr. Waterhouse?
Here.
Ms. Yanis?
Here.
Dr. Noland?
Here.
We have a quorum.
Thank you.
Thank you. Now we'll move to item number 2 on the agenda, an introduction of the public. Maybe start here in the front row. How's that? Thank you. Welcome. We'll move on to number 4, review and approval of the January 23rd and 24th, 2019. Oh, I'm sorry.
Yeah.
My bad. Now we're on item number 3, public comment on items not on the agenda. Okay, seeing no public comments, we'll move on. We need to review and approve the January 23rd and 24th, 2019 board meeting minutes. I guess I'll start on page 7. 3/4 of the way down the page, Dr. Cheryl Waterhouse moved and Dr. Jamie Nolan seconded a motion, but there is no evidence of a vote. We're on page 7. Under the board return to this agenda item at a later time, and then we're about 3/4 of the way down the page. There's a bullet point. Dr. Cheryl Waterhouse moved and Dr. Jamie Nolan seconded the motion to continue working with the legislature, but I don't see a vote there. It was a motion, so I think it did. Okay. And then I have one more item on page 9 under 13. The very last sentence is a bit misleading. Assemblymember Colera's office actually were requesting money for human research, and they were considering or researching whether they could use some of those funds to be allocated to animal research. So it was a little misleading there. And those are all the corrections I have. Anyone else? Okay, so can I have a motion?
Motion to adopt.
Second. Call for the vote.
Do we have Ms. Bowler or Dr. Waterhouse seconding? We had 2 seconds.
Okay, either one.
Oh, okay, I'll go to Kathy. Okay. Ms. Bowler?
Aye.
Dr. Bradbury?
Yes.
Ms. Laredo?
Aye.
Dr. Nunez?
Yes.
Dr. Waterhouse?
Yes.
Ms. Yanis?
Yes.
Dr. Noland?
Yes.
Motion carries.
Next item on the agenda, a report and update from the Department of Consumer Affairs, which has been presented to us as a letter.
Yes, so the Department of Consumer Affairs was not able to join us today, but they did provide an overview of the updates, and I provided that to board members last night, and also provided the public copies of the document. It'll be posted on our website shortly as well. So if there's any questions from the board that they would like to ask DCA, I'm happy to pass that along and get information for you.
I just had a question on the status of the EO report on salaries.
What's your question?
When is it going to be finalized? They keep saying soon.
Mm-hmm. Right now they're they're aiming for the end of April. So hopefully that'll be the last deadline.
Okay, thank you. Okay, moving on to number 6, review, discussion, and possible action on the MDC report. Dr. Pollard.
Good morning. So, some of you were in attendance yesterday, and this won't be that new, but we had a very good discussion on 3...
Dr. Pollard, is your microphone on? And can you turn the volume?
Test? Okay. We had discussions on 3 main topics yesterday. Good discussion. First of which was corporate practice, and this centered on, I'm going to break it down into 2 areas. There was a survey that the Veterinary Medical Board sent out to licensees, so some 9,000 veterinarians had opportunity to receive it. About 500 replied. It was a survey of a half a dozen questions regarding individuals' experience in working for and in corporate entities. It probably was the majority focus of discussion. It involved the concern that veterinarians are receiving or working under undue influence of non-DVM ownership. The survey was anonymous. It wasn't statistically qualified. It was very interesting, some of the conclusions that Stuart Ekman and Christy Pawlowski, who've done a great job on this subcommittee so far. And I think the plan, as I understood it in the discussion, was to continue this survey, maybe a modification thereof. There really wasn't enough time. I think it was put out just a week ago, a long week ago, to evaluate many of the questions and go over those. So I look forward to hearing those discussions at the next meeting. The second area that garnered a lot of discussion was the February 2nd, 2018 memorandum from legal counsel to the Veterinary Medical Board members about background and proposed revisions regarding corporate practice non-DVM ownership. And there was a good interaction between public members, one group, a large group, VCA, representing VCA, and a couple of other organizations were present, but it was the single entity that spoke up in our meeting from the public regarding corporate ownership. A couple of other people weighed in, comparing what is done nationally in other states. The term PC states, private corporation, public corporation, I'm not sure what the PC stands for. But an attorney referred to there being 20 other states that do not allow non-veterinary ownership compared to we in California. And then the last thing I'd like to mention referred to the survey, and I think it was important to recognize, given the nature of the survey, the audience to whom it was sent, and then the replies, I think it would be fair to say there is some inherent dissatisfaction in many people's employment situation just by the nature of being an employee versus running the show. So a large percentage of the 40-ish page packet involved examples of contracts, non-disclosure agreements, and we didn't get to those at all. I don't know that we needed to. We may or may not at the next meeting. Questions?
In regards to surveying the issue to see if there truly is an issue here, do you think that there's any way to get some input or feedback from the consumer on whether or not they've experienced some corporate influence on the way their veterinarian treated their pet? It might be difficult to know. Has there been any complaints? Do you think it even could be proven?
So before you speak, do you mean specifically a complaint from a consumer about the care their pet received in the context of it being given in a corporate entity versus not?
Correct.
So a couple things. Complaints are not public information, so we wouldn't be able to disclose any of that information. But I can say that consumers, let me back up. I would caution the board or the committee to look at the absence of complaints as an indication that there is no problem, because the consumers don't know. All of this happens behind the scenes, and all they know is what their veterinarian is telling them is necessary. So if the veterinarian is giving products and prescribing medications, the consumer is going to trust that. We would get complaints if something goes wrong, and we would look at that. But even during that investigation, it would be very hard for us to, unless the veterinarian just came out and said, my boss told me to do this, we would not know in that investigation if there was undue influence.
And I understand that and appreciate it very much. I wholeheartedly agree that the absence of complaints doesn't mean that there's not a problem. But it was asked under the initial question, is there any way to know, you surveyed the licensees, but there's no way to really survey the public on this issue, on whether or not it is an issue. Because there is inherent bias on the survey. As you mentioned, probably most people are not happy with their contract, and given an opportunity to say something against it, many will take. So my question is, how do we know really what the pulse is on this issue? And I just used complaints as an example, not necessarily the only example.
I hear where you're coming from, and I think we have to be conscious of the fact that it does smack of a Yelp review to a degree, where the loudest screamers are the most dissatisfied individuals, and they may or may not have the most valid either concern or objective observation of what's going on.
I think it is important to add, though, in the results of the survey, while 30% was indicative that they were unhappy with what was happening, 70% was they had positive comments in their corporate structure.
That's a good point.
Could I ask a question on the survey process-wise? I know there was about 500 responses so far. Is there, and I assume the staff were the ones that emailed the survey out to the vets, can we ping the non-respondents one more time and see if we can push up the response numbers a little bit more?
Yeah, we definitely can send it out. I think there were a couple tweaks that the committee is considering, the subcommittee. But yeah, we definitely can send out another round of emails to everybody.
Okay, thanks.
One of the issues I have with the survey is there is no control, so you aren't analyzing or getting any responses from those that perhaps aren't under a corporate umbrella that's not a non-veterinarian. So it really makes the statistics pretty irrelevant if you ask, if you look at it.
And I think to the subcommittee, it wasn't necessarily to make any statistical analysis of it. It was really to just get an idea of, is this truly an issue? Because it hasn't been, no one has come forward during the stakeholder meetings. And so we wanted to first see, is it something worth continuing? And I think that this was the start of that.
And I would agree with that it's very hard to make a survey statistically robust. That's a tough thing to do anyway. And as I listened yesterday to the meeting, I thought that this is a very complex issue and it has a great deal of legal implications that are very far-reaching. And I don't know if it's appropriate or not, but my feeling was that it might be relevant or important to do some sort of a task force or something that we could really allow a group of people from all different areas, including consumers, to get involved in discussing this and looking at it from many different angles, like we did with the animal rehabilitation.
Doesn't the MDC have a 2-member task force on this right now?
Yes, and I think they've done a great job, but I do think that because of the complexity of the issues, and the involvement of many different groups of people, it's just a thought. I thought it, I guess you were involved with the animal rehabilitation. I guess you have a maybe different opinion of the task force with animal rehabilitation, but it's a pretty complex issue, and I don't think we should treat it lightly.
So were the corporations given notice about the meeting yesterday?
Yes.
So all the corporations were notified, so if they didn't.
We also sought for them, if they couldn't appear, we encouraged written comment.
Okay.
And we received written comment from one group.
So I would, if we had one representative yesterday, but if the others are not here, not showing up at our task force that we had yesterday, then I assume that they're not concerned about it.
I guess I'm not so worried about the corporate response. I'm thinking of other veterinarians, the public, other entities that will be affected by this issue.
It would, kind of following on Dr. Nolan and Dr. Waterhouse's comment, it would seem more likely that a corporation could send a representative to the MDC or the VMB meeting and make their points much more reasonably and easier than would an anonymous replier to one of these surveys. I mean, that's just not going to happen. Obviously, it isn't going to be anonymous then. And then a question, Dr. Nolan, do you mean a task force different than what the two current?
I apologize. I'm just thinking out loud, I guess, in some responses or some respects, because we mentioned these large corporations, and obviously they are affected, but there are many incorporated veterinary clinics that will be affected depending on how we respond to this, and I'm not sure they have been made aware or are at this table. That's one area that I'm concerned about. And the other is the consumer. I don't know, like Dr. Nunez said, I'm not sure how to bring them into the discussion, but it may drastically affect them as well. But a task force may or may not be appropriate.
Are you finished with your report on this, or did you
Yes.
have more to say?
No,
I have
I'm good.
tons of questions, but
Okay.
I wanted to give you the opportunity to
Thank you.
possibly answer them first.
I don't have any more comments on this topic.
Okay, then I'll ask my questions. We tasked back to the MDC proposed regulations that were originally adopted by this board and then rescinded and sent to the MDC, and that had proposed statutes and regulations. The statutes, I think, were lifted directly from the California Medical Board, and the specific difference from what's currently in our Practice Act to what is proposed is a change to not allow corporate entities to practice veterinary medicine, which I think is obvious, and I think it's fine for consistency's sake to make it similar to what's in the medical board. And then there was also a section on regulations that was lifted from the Texas Practice Act that spoke a lot about how to monitor whether or not influence is being made upon veterinarians. Did you talk about your likes and dislikes on the proposed regulations at all?
The only specific question along that came up, I asked about the difference between the medical and the veterinary act, and I stand corrected. Dr. Waterhouse and Dr. Lazarchev did ask the question, if we were to adopt these revisions, what would be the harm? And I would be faking it if I said we came to a conclusion, but the public had their say and the committee members discussed it briefly, but I think that's something that needs to be fleshed out, because clearly that would, as you've alluded to earlier, not just about non-DVM ownership, undue influence, but a lot of I mentioned the contracts and non-disclosures and things that we didn't get to, and it just wasn't the time, frankly. Those are some issues that really would put a lot of work on the Veterinary Medical Board, maybe more than what we want to do.
Yeah,
or should
I think
do.
it's big enough of a topic that it could justify a task force. My second question, do you want to?
I was just going to add too that the group who's here today and can speak during public comment, they also said that they are willing to provide specific concerns to the language in writing, and I think that would be very helpful for the committee and the board to see as it relates to the statutes and the regulations that the board adopted.
Okay. The second issue that came up was exactly how influence is accomplished, and that was mostly through employee contracts and possibly hospital protocols. So do we think as a board, is it appropriate to start to have oversight on employee contracts or hospital protocols? Or is that overreaching?
I would hope not, particularly the contract element, because clearly there are people who work for non-incorporated entities that have contracts, and it would seem only consistent if we just dealt with the VCA and Banfield and Pet Pathways that we'd have to deal with Dr. A, B, and C also. And that's just, for my part, I don't see that as our mandate. With regard to hospital protocol, I took away from Christy Plowski's comment that the consensus she took from the brief analysis of the small group that responded, the 30%, the biggest influence is through their pay. So I did not get the impression that Stuart or Christy had received input that had veterinarian working for a corporation unhappy with the way they treated parvo. Rather, they were more likely unhappy about, you need to use this drug and do it in this way. Not that you can't hospitalize or you can't use antibiotics or whatever. Does that help?
Yes.
Can I ask him to clarify the statistics, the numbers on the survey for
Sure.
everyone, and the percentage of the total survey that was respondents?
So I was writing madly, and I've got 29% blank and 36.21% products and services. I'm sure Jessica can correct me, but my impression was there were 500 plus responses.
But I think that the ones that that Christy was referring to was 474 she had received, and then there were some additional that came in after she evaluated them.
Right.
And that was 474 out of 8,900. So you're talking about a little around 5% respondents.
Right.
And of that, 30% had concerns, and 30% of those respondents that indicated they were employed by a corporation.
And had some dissatisfaction.
Did the survey indicate whether it was a corporation owned by veterinarians or made up totally of veterinarians or
Good
a
point.
non-veterinary corporation?
It did not.
Okay.
There are plenty of corporations that aren't VCA, aren't Banfield.
Thank you.
It's my impression then that pay is dictated through the employee contract, and the proposed regulations kind of specifically dealt with that. That's such a complicated issue and far-reaching. I have hesitations about including that in regulations, especially if I don't see how it can be just limited to corporate practices once it starts the whole legislative process.
Agreed.
And I would think that the larger the corporation is, the more people are involved, like HR and legal counsel and so forth, to make sure that it's appropriate, the contract, and not egregious in what they're having the veterinarian do. It's probably the smaller mom and pop places that might have really outrageous demands from their young, inexperienced veterinarian. That wouldn't be covered if it's just exclusive to veterinary or to corporate practices. I think that's probably where the potential for harm is greatest. So that would be a difficult thing to push through, I would think. Not that we shouldn't give up on trying.
I completely agree, and I would add that the term corporate ownership is not a single entity either. The company that has 1,000 practices versus the company that has just a couple. And many of them are not even geographically in the same neighborhood. So the way the mom and pop store operates and the variability between them and the variability between those, pick a number, maybe 100 corporations that own veterinary operations. There must be tremendous variability between them too.
Then the last point, it may be surprising you, but you probably already know, we're possibly adding another issue on the task to the MDC in regards to ownership of a facility and managing licensees. Is that whole issue possibly going to also be engulfed by this issue? Whether or not VCA owns a hospital building and all that stuff, could that possibly overlap?
I don't know the specific answer, but I did discuss that both in the meeting and after with Jessica, and we've already established a subcommittee for it. So at the moment, it's two separate groups.
But there could potentially be overlap with who owns it and
Yeah, I would agree.
managing licensee holders and so forth. Okay.
So, I was sorry. Yeah, you want to go? So where are we? Because I just want to clarify where we are. I was there yesterday and listened to everything. It was a really interesting discussion. And there were a lot of other facts brought out. I think Bonnie may have brought in testimony from that 20 other states do something similar in terms of conforming with medical. But Tara, I may be wrong on this. I'm just wondering where we go from here on this. It is complicated, but I'm not so sure. I think we want to keep looking at it.
My understanding from Ms. Lutz's testimony was that there are 20 other states that only allow professional corporations to own the premises.
Oh.
So there is no general corporation ownership like we have. We also have professional corporation statutes, which is the Moscone-Knox, which requires licensed professionals to own and be officers of the corporation. But there is a confusion in our law insofar as we do not limit ownership of the premises to only professional corporations. We only allow professional corporations to practice, but that was the intent of the proposed legislation, was to draw a more defined boundary between general corporation ownership of the premises and of a business. So, did I answer your question? The 20 other states they do not allow for general corporate ownership that we see in California today.
It's actually something that had not occurred to me until Dr. Nunez mentioned it, that this is not an issue that's limited to corporate practice. There are other entities like schools and animal shelters where somebody in a management position is not a veterinarian who may try to influence treatment. So I found myself in that situation once. I had a very well-connected veterinarian in charge, but I can see how that would extend to other entities. So that may be something to keep in the back of our mind as we go through this.
Yeah, similar to what you were saying, I was just thinking about this. I think it sounds like the goal is to prevent a corporation from dictating medical treatment based on, we lost our contract with Bayer, you can't use Baytril, and now we don't have an injectable antibiotic that treats gram-negative infections and so on. I think that's the goal. Am I correct in that? Okay. But in just a privately owned entity, we can also see managers and veterinarians making deals with drug companies and only having certain antibiotics on the shelf, and that's still going to be acceptable. So I don't know that what we're trying to achieve by limiting corporations is really going to achieve that for everyone. It's just a thought.
Any other comments from the board? I'd like to open up for public comment on this. Anybody?
I just say one thing briefly. Folks who were running for me yesterday, apologies for. Sure.
You should push the button.
Mark Cushing with the Animal Policy Group, and I met with you all in Davis back in January. I appreciate a very, I think, robust conversation yesterday with MPC members as well as with council. I do think there are very separate issues, and the more you throw all the issues into the pot, it is complicated. And I think even though California staffs veterinary board and has an MDC, which is a uniquely very effective entity, you're asking a lot to cover all those issues, and certainly in one meeting I don't think it's even possible, because the employment contract issue is extremely complex. It just is, and if you weigh into that and you're trying to govern types of employment contracts, I think you just need to take the time to do that in a way that doesn't have a lot of unintended consequences. The separate matter which council raises of just clarifying, so nobody has any doubts that no entity can practice veterinary medicine in California. No legal entity other than an individual licensed by the California Veterinary Medical Board per the Practice Act, which I view that as already the case, because only individuals can be licensed, so by implication nobody else can be, and non-licensed persons are prohibited by explicitly in the Practice Act from practicing veterinary medicine, so you don't have to do that. But I completely agree there was no harm done to state it as boldly as you want. No entities can practice veterinary medicine, period. That would not be controversial, and no one's asked me, the Mars Veterinary Group that I work with, including VCA, no one's asked me to challenge that. The issue gets into distinguishing among types of practices. Shelters are a good point. The question of having non-veterinarians tell veterinarians how to practice and what medical judgments and what treatment and so forth.
that applies, in our view, across the board to all practices have that risk, and all practices have economic pressures. But also, so do all professional service firms in California. Law firms, accounting firms, engineering firms, all have economic concerns. The question is, don't cross the line and take the privilege of being a veterinarian, which is governed by Practice Act, and sacrifice it for economic concerns that aren't recognized by the Practice Act as the qualifications. But that applies across the board. And I just think saying corporate structure creates dangers and others don't isn't fair. And my point has been, it's a stigma placed over corporate practices in a state that has a tremendous number of corporate practices. And the 45 or 50, and I did a count through a colleague last evening, the 45 or 50 corporate groups now operating in the U.S., in many cases funded privately, what's their primary market? California, because there's more people here, there's more pets here. So, yeah, and they range in sizes from 2 practice groups to, Banfield, has 1,100, not all in California. So I just believe if you want to get at the issues of, quote, undue influence, the fence shouldn't be so narrowly drawn. And I don't think there's justification for that in any kind of record. So I think the process, obviously, if it continues, which I'd understand why you would continue, you need to draw more in. Dr. Waterhouse, you're right. Corporations aren't showing up. I talk to a lot of practices. They'll say, well, are you going to the hearing, Mark? Even though you don't represent us, you seem to know how to talk. You'll probably raise the points. We've read your memo, and I've said, well, it wouldn't hurt to weigh in. So, I continue to tell people, because they all care, but they don't monitor board meetings and MDC meetings, and they aren't headquartered here, and all these excuses. Sorry, I'm able to be here, but I do think you could get legal counsel and others involved on the technical employment issues if you really want to go down that path to look at how the board would regulate employment contracts with veterinarians beyond the broader way you do it now. But those are my comments. I thought it was a good discussion, and we'll obviously stay engaged. And I do appreciate Dr. Tams, the CMO for VCA, who's been here in California for 30-some years, testified. And I think more people like that need to step forward and give their expertise.
I just have a point of clarification. The proposed legislation is not about interfering with employment contracts. I don't think that should be the focus of the discussion. I think the intent was just to draw the bright line between corporate ownership and veterinarian practice. And when I'm looking at the proposed legislation, it does mention employment agreements, but only insofar as it would prohibit the employment contract or arrangement to provide for rendering supervision or control of the professional judgment or services of the veterinarian. So again, it's just about clarifying where the line is. It's not about diving into employment contracts to start limiting what the general corporation can tell the veterinarian to do. It's just about making sure that the consumers are protected from the corporate entity trying to bilk the consumer for their own financial gain.
Could I comment on that clarification? It is not, to me, without consequence or meaning that the draft regulations suggested that the board could adopt or should adopt, if legislation were enacted by the legislature, dive in great depth to the employment relationship. So they're linked. I understand that the legislation, step one, but they're linked. It's a package, and I think that that's useful. It kind of indicates the thinking behind where this would go. Secondly, the term services, you say judgment in the language, in the draft legislation, but it's judgment or services. And that word services, I guarantee you, will make a lot of attorneys wealthy, and they will stay up late at night debating now what that means by way of services. Because not every service that a veterinarian provides, right, and a veterinary practice provide, not every single service is within the scope of the Practice Act and the specific license and privilege granted to a veterinarian. There's a range of services. Obviously, some veterinarians groom, some board, some sell flea tick product. A whole lot of things happen. Some give advice through RVTs, some give advice through vet assistants that are not not unlawful, but they're not within the scope. And so I think even parsing those words have a difference. Lawyers exist because of words and they interpret them. And I just think you want to narrow the scope as much as possible. But the influence issue, I would just suggest you can get at that very bluntly and directly, but it wouldn't draw the line just at corporate ownership. You could do it in a way that would clarify to everybody, you have to be a person in an individual, and you have to meet the requirements of the Practice Act, and it has to be provided you through the board, period. And if you're not in that category, you don't practice veterinary medicine in California, period. So, but I think we can get more people involved, and I think we can provide more assistance and counsel to the NBC and more examples to consider if the process, as I understand, goes forward. And I'll do what I can to get more people than the person speaking engaged. Thank you for the time.
Any other comments?
Good morning. My name is Leslie Boudreau, and I'm going to take off my CARFTA hat here for a moment and put on my practice manager hat. I'm also a member of the board of directors of the Veterinary Hospital Managers Association, the VHMA. And I just encourage you to distinguish between the term corporation, which is a legal entity that is different than a corporate consolidator, which I feel is where the survey went out to distinguish between corporate consolidators and private entity. A corporation is a financial and tax strategy that businesses choose to incorporate for those tax and financial benefits. But we keep using the term corporation to distinguish, I think, where we're trying to draw the line between a corporate consolidator, a large group of corporations owned by a non-veterinarian entity or a non-professional entity, and that the corporation term keeps being bandied around, which I think we need to distinguish with perhaps calling it corporate consolidation. Most veterinarians, even solo practitioners, are incorporated for the business purposes and the legal and tax purposes. So I just wanted to clarify that, because I keep hearing the term corporation as some sort of necessarily a negative term when it's strictly used for financial purposes. And my other comment is also when you brought up the term of protocols, and I realize that Ms. Welsh has said that's not the intention, but we have national organizations like the American Animal Hospital Association, or AHA, which encourages practices to have standards and protocols to make sure that the best medicine is practiced. And I'm sure our legal representation here with Ms. Lutz would also encourage that all hospitals have some sort of medical protocols to make sure that they are meeting minimum standards, versus using the term protocol in a negative way that is somehow creating a burden on the veterinarian to practice in a way that they might be choosing not to. But I think having a base minimum protocol should be the standard in every practice. So I would encourage you to think about that before using the term protocol as a negative. Thank you.
Thank you. Anyone else? Okay, thank you. Anyone from the board?
Well, just to wrap it up, I wouldn't be in favor of a task force. I think it's too soon for that. But I would encourage Dr. Pollack to continue his good work on that.
Dr. Pollard, would you like to move to item B?
Please. Actually, no. B is going to be quick and easy. We got to get through hard and difficult first. Cannabis guidelines was the second topic of substantive conversation. So this is the second time we have talked about this in meeting, first being in January at Davis. And everybody knows the Veterinary Medical Board, is tasked with putting up guidelines on the website by January 1st, 2020. And though this didn't come up in the explicit conversation yesterday, discussion behind the scene about the question whether we should put up preliminary guidelines to help people that have active questions right now was solidly voted down because it has the risk of creating confusion. I think it's fair to assume most licensees do not frequent the Veterinary Medical Board website on a regular basis. And those that do would know how to find the current draft of guidelines. You go to this tab, you scroll down, and as you all know, they are in the meeting, what we call the packet. So it is out there, but I think I would predict we're going to come up with the final version on December 31st, 2019. Just heads up. And so with that, Meg Warner, the other subcommittee member who's doing a fabulous job, she opened the discussion yesterday by saying, from the perspective of a licensee, what would they need when they go to that website January 1st, 2020 and thereafter. And so what we want to do is, in broad strokes, balance general guidelines that are accurate with not too much detail or proscriptive writing that would put both the board and the licensee in too strict a corner. So with that, the guidelines that we worked with and walked through yesterday, we had some good input from public members. We did a little editing. We changed a couple of bullet points. That will very likely be the template at the July meeting that we represent. And for some who perhaps were here from elsewhere or here for the first time, I made the statement that the guidelines are the 3-page document that were the beginning of that packet. The remainder of what was included in the packet were mostly there for discussion fodder of the committee. I don't know what will ultimately be put on the website, but it's not, at least at this point, the intent that all the other things that were, I think, 40 pages total, going to be in the guidelines. It is a dynamic process. There's pending legislation, as we all know, and we will roll with it. We will work with whatever comes down the pipe, and I think that's why truly the realistic expectation is we're going to have to wait until the very last minute to put it up on the website. And then in 2020, it may morph from there. I guess that's all I have. Questions about cannabis?
Thank you very much, Dr. Pollard. Is there any public comment on the cannabis issue that was discussed at the MDC? Any other questions for Dr. Pollard?
I do think the guidelines are accomplishing what they're meant to accomplish. So I think that's good work. I would, even though you had mentioned that the supporting reference material after the guidelines, those are the references to the Farm Bill and also definitions and so forth. and related FDA materials. I think that would be helpful just to include as an appendix or something to the guidelines that could be easily accessible to licensees. But there was a point raised that the definitions that you have here are not consistent with other definitions that are already in the California Code. So perhaps they should be similar to what's in the California Code.
Sounds good. And I think the vote on what gets included on the website is in your hands. So
Right.
we'll put it out there.
That's what I was going to ask is it your plan or our plan that in July at MDC you would finalize and then bring them to the board for the October meeting that the board would accept to post then? Is that what the process would be? Prior to the end of the year or January 1?
I would predict that we're going to do the first part of what you said for July. As you know, there'll be votes on legislation or not. Signing on legislation or not in September. So I think between July and October, there's more variability about what's going to happen than between now and July. So I can answer to July, I think, easily. Maybe we're done in October, and it's a finished product then, because there won't be any more legislative intervention between October and December, and we won't have a meeting after October, right? So I suspect we will have to propose something semi-final by then.
And a possibility could be that if the board or the MDC is not ready by October, then to have a teleconference toward the end, because the governor has in October to sign the bills. Right. And so if something changes and we want to make changes to the guidelines, we could have a teleconference to amend them.
Thank you.
The last thing I would say is that I do think that this is accomplishing what we have been asked to do, but we're fooling ourselves if we think that this is what veterinarians want to know. Veterinarians really, really want to know when should I use this and how should I use this, and so the issue is probably not by any means over after this is accomplished.
I would agree.
I have a feeling we have some public comment. Sure, come on up.
Good morning, Paul Hansberry. I just wanted to clarify one thing, that the guidelines that are proposed by 2215, or were mandated by 2215, should the proposed legislation, the Senate Bill 627, pass and be signed by the governor, that wouldn't negate these guidelines, because according to 627, in order to be a qualified veterinarian, you would have to go through the continuing education course, which would give you more detail, more information to be able to recommend, so you know what you're talking about. For those who choose not to incorporate cannabis into their practice, these guidelines would be a very valuable tool for the inevitable questions that they would get. I just want to clarify that distinction. Thank you.
Any other comments or questions? Looks like, okay. Dr. Pollard, do you want to go ahead and move on to the minimum standards and protocols for shelter medicine?
Yes. In your packet under 6B is the proposed language that was discussed and voted on at the January meeting. And I guess I don't have anything to add unless there are questions about it.
Do members of the board have any questions on that? I have a couple while they're looking. And they're grammatical, basically. On page 1, item D, the facility temperature and ventilation shall be maintained so as to assure the comfort of all patients. Maybe I'm being picky, but are we referring to the temperature of in the facility, the ventilation in the facility, and are there other things in the facility you want to address? I feel like that sentence is a little misleading. Are you talking about the ambient temperatures in the facility?
That's what I took it to mean.
Dr. Sullivan?
Dick Sullivan. I'm working on this proposal. This is actually language taken from existing 2030. So if we change things here, we can go back and change the others too. But the number at the end of each line is where it came from, the original 2030 legislation or the regulations that we have. We put it in there so everybody would have a reference where it came from, and also so we didn't miss anything.
So I'm assuming that the facility shall be maintained, the temperature of the facility shall be maintained, and the ventilation of the facility shall be maintained. That's what you mean, right?
Yes.
Okay.
I don't know what the original intention was, but we didn't change anything when we brought it over from what is existing right now.
So maybe I shouldn't bring up on page 3S that you mentioned, this is on S, when performing clean surgery. For purposes of this subsection, clean surgery shall mean the performance of a surgical procedure for the treatment of a condition, blah, 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 that you say do not warrant. It should be does not warrant if it's correct English. You okay with that? And then the last thing that I was wondering about is at the very end of the document on G, rabies vaccines may be administered to an owned animal. Are we supposed to address by whom? Who's actually administering that, or is that somewhere up above? Because I wasn't aware that a veterinary assistant could administer a rabies vaccine. Is this?
Grant Miller, CVMA. So Dr. Nolan, that part there was the major meat of our discussions with the shelter community relating specifically to animal shelters. They have situations where they will have an animal that is unowned, that's available for adoption, and the animal will then get adopted out with some kind of a voucher or a promise agreement signed by the adopter that says that they'll bring it back in to finish its vaccine series that are required. And so in that small subset of animals that they see that, they are now technically owned, normally in order to administer a rabies vaccine, the veterinarian would first have to establish a VCPR, but the shelter community essentially wanted a buy on that, so that for this small subset of animals, they could just have the staff do it without a veterinarian seeing it and without having a VCPR, and so that's where that came from.
And so any of the staff members could administer the vaccine, is what you're saying?
Right.
Shouldn't we make that clear? Because it seems like it's confusing if we have other statutes that don't allow that, or you just think that is...
I have no comment on that matter. That's for you guys to discuss.
Comments on that?
You're asking why in this particular section we're allowing...
No, I understand why we're allowing it, but I feel like the wording is very nebulous and not very clear. because if you look at other statutes, it says you have to be under direct veterinary supervision and an RVT, and here shouldn't we say a veterinary assistant?
Which part are you talking about again?
S. We're on S.
S.
Rabies.
Oh, I'm sorry, it's G. I didn't have my glasses on. Yes.
For 2030.6 G.
I think that it's under the CCR section 2035.5, the duties of the supervising veterinarian with healthcare tasks for the RVT.
Okay, so it is clarified. My mistake. It is clarified at the very, yeah, okay. Now I'm fine with it. So now I've given you all time to look, so anything else?
I don't know if you want your first question about the ventilation.
I think it's answered appropriately. There are commas between it.
I found the section was referenced to.
I'm good with it. So any other comments by the board on the language?
Motion to, well.
Public comment.
Oh.
Thank you. Alan Jersey's Riverside County Department of Animal Services, up until yesterday at your service. As you all are aware, this is a very complex issue. We struggled, the MDC struggled, continues to struggle with the definition of a shelter and who should have a premise permit for the tasks that are routinely performed in animal shelters, sometimes, most of the time, without the direct, certainly, or indirect supervision of a veterinarian. It was mentioned that small subset of adopted animals that need to get a rabies vaccination before they leave. More importantly, however, a lot of us feel is that subset of animals that are owned, that are redeemed by their owner at a time when, even in our case, the veterinary clinic may be closed and we have RVTs on staff, and the owner wants the animal. The owner has not been compliant. In other words, the reason why the animal's there is it was stray at large, unvaccinated, unlicensed, doesn't have a microchip in our case. We don't want to lose that opportunity from a public health perspective to vaccinate that animal. And that is the impetus behind this. Whether it's a small or a large subset, it is nevertheless important.
Thank you, and I agree with you, and I apologize for not reading the title more carefully. But I would like to take this opportunity to publicly thank you for your years of service on the MDC. Dr. Drusis, it's been a pleasure and an honor to have you, and we're very grateful.
I appreciate that, but I wish you guys would stop. This is embarrassing.
I was going to say, I wish you were more involved in the preparation of this document.
Yeah.
I would have liked to see that.
Thank you.
So are we looking for a motion to, or do we?
Looks like more public comment.
Oh, we have more public comment, sorry.
Bonnie Lutz. I'm an attorney. I defend veterinarians, but I also have been very involved with shelters and shelter medicine, and I've been involved with several shelters that were inspected, and so I'm aware of those issues. And I know you've worked really hard on this, and I'm sorry I wasn't at the last meeting to provide any comments, but I have just a couple of general comments that I did talk to Dr. Sullivan about, and I just feel like I have to bring up. One is in section N1. I'm looking at this from the point of view of shelter veterinarians calling me and saying, you know, what does this mean? Again, I was at the December 2017 task force meeting, but husbandry standards, I understand why it's there, but it's not really well defined in my mind, and I know that that's going to be something that veterinarians are going to say. And section 2030 D1 does not include the term husbandry standards. So I think that to clarify things, it might be a good idea to define, and I understand that the reason why it's there is to allow the inclusion of animals other than dogs and cats. So I do understand that, but your run-of-the-mill veterinarian in a shelter is not going to necessarily have access to or know where to look for what a husbandry standard is. So either I would recommend either citing to where that's defined in California law or defining it somehow, just so it's clear. If there is an inspection, because that's what I anticipate is, the inspection and then, them getting dinged for not upholding husbandry standards and having none of us know what that really means. The other comment I had, which was similar, was on N3. And I know that you struggled with this, and it's still a struggle, especially in the older shelters, but the definition of the veterinary premises. Because, in a lot of shelters, it's not clear where the veterinary premises begins and ends. And I've been personally involved with inspections where we had to basically call out the inspector and say, no, you can't go wandering around all through all the kennels because you don't have authority over all of that. You do have authority over the veterinary premises. So even if you just said, as defined in 4853 or somehow so that we can more clearly define what you mean by the veterinary premises, because in a big shelter, there's a lot of area that is not included with the veterinary premises. Because if you've got hundreds of animals that are housed in the shelter that aren't being treated by the veterinarian or in any way getting any medical care, those animals are not on the veterinary premises. So, that's just another problem I see. The other situation is in R1. Because then when you look down at R4, it talks about surgical room. I just think it would really be nice to clarify in R1 where you say a room, comma, separate and distinct from all other rooms, and then just do parentheses, surgical room, and parentheses. So it makes it really clear, again, what we're talking about, because unless you've actually gone in a shelter, and especially an old shelter, and walked around to see how that building evolved, and again, these people that are running these old shelters, they're at the mercy of their city council, their county council. They can't, or their county board of supervisors, they can't necessarily go in and do whole scale, redevelopment. So a lot of them are operating under sort of, conditions that are difficult. And I know that they've worked really hard to maintain the standards that they need to maintain. So I'm not suggesting that we have a lower bar, but I just think that it would be good to define surgical room so that we're clear what we're talking about. And then by the same token, on R5, I would recommend that you use the same language that is used in 2030 G5 to clarify this access from outside the facility, because the way it's written, I can see somebody saying, okay, well, that door that goes directly from my surgery suite to the outside of this building, that can be open when we're not doing surgery. And I know of an old facility which is now closed where that actually occurred. There was a door that went right to the outside, and when they weren't doing surgery because of airflow, they opened that door and there was a pass-through that went through the surgery room. So, and that's not a good thing. So I think, and I know that the reason for this whole idea is that if you have large animals, you have to have some kind of an access to the outside. That's just a different ballgame. So that's why I would recommend you use the same language that is in 2030 G5, which talks about large animals. And again, I think you've done a fabulous job with this, having been at the early meetings and the early task forces, but I just think some clarification might help down the road. Thank you.
Wanted to see if maybe Dr. Pollard or Dr. Druses remembers. I vaguely remember a discussion on N3 veterinary premises and the discussion that there is a potential to be performing veterinary medicine in the kennels, and that there was some clarity needed on where it ended and where it began, but I don't remember the outcome of where we were with that. Dr. Miller.
I was actually going to make comments on the other two sections that Bonnie had. So if you guys want to discuss that part first, then feel free.
Could I defer to Dr. Drusis?
Hence my assessment that this is not a simple matter. It's quite difficult, and the MDC did not come to terms with where the premise begins and or ends. And as a result, that is an open question for the board to discuss. From my perspective, at any time that I had that our facilities were inspected by a inspector, I let them go everywhere they wanted because that is the standard that we in Riverside have attained. I realize full well there are other jurisdictions that may not have that capacity, that ability, capacity, but I have always felt that we should be in the business of raising standards in shelters and not lowering them. I'm not suggesting that animal shelters should look like small animal practices. They obviously can't. Nevertheless, the example I use all the time is cross-kennel drainage. There are innumerable shelters in this state where the conditions are such that certainly from a consumer protection standard, you would not want your animals to be impounded in a kennel where 2 kennels over, a parvo puppy just got in, and the only method to clean those kennels is to spray it all down, and everything passes from one kennel to another, exposing all the other animals, at least in that row, to that infectious disease. To me, that is the problem that we have to solve. The other issue as to where veterinary medicine is practiced, yes, we have treatment and receiving, where we afford the animals prompt and necessary veterinary care, but we do also go into the kennels to administer, to do minor treatments, and as such, we feel that part of the shelter should be open to inspection as well. I'm not sure I covered everything, but I guess I'll sit here for the time being.
So, Grant Miller, CVMA, my goal here is to try to provide as much recollection as I can regarding the conversations as to why we chose this language. And if you will recall, the board asked the CVMA to put together a task force of stakeholders to work on this issue and bring forth this language. And while the language has been substantially improved by the MDC, the original bones of this language came from a task force that we had put together a few years ago. And when Bonnie and I discussed this morning, I had only drank half my iced tea, so I didn't have enough caffeine on board to remember where some of this came from, but I wanted to provide some of that information to you in light of, if you're going to consider some of her comments, I'd like to give you some background. So in relation to section N1, where it talks about husbandry standards, this actually dovetails nicely with what Dr. Drusi's just mentioned about the cross-kennel contamination. So currently, and Patty's not here to confirm this, but currently we are aware that in at least a regular veterinary premises, the effective separation of animals in kennels would prohibit the cross-current flushing of the kennels, going through one or the other. The reason why we put in the word husbandry standards is because when you look at the minimum standards that we drew from, that was for a small animal fixed premises. So the husbandry standards for dogs and cats in a small animal fixed premises is different than what you may see in a shelter in regards to the types of animals they have there. So for instance, the example that we drew was horses. So effective separation of horses is much different, and dare I say it, much lower than that of dogs and cats. So for instance, effective separation of horses is a fence. They sometimes can touch through that fence. They sometimes can get their heads through that fence and sniff the other horse's excrement, whatever that is. That's generally within a husbandry standard for horses, but that same husbandry standard is not there for dogs. And so what we tried to do was incorporate some language that would allow some leeway, if you will, or some latitude to accommodate all the different types of animals that you may see in a shelter, and let those animals each be evaluated based on husbandry standards for that animal. So when it says effective separation, that still holds true for dogs, that they can't touch noses, that they can't have cross-contamination. But for horses, that wasn't really going to hold up. And so we tried our best to choose language that would make that work. But I agree with Bonnie, it is somewhat ambiguous, but it's as close as we could get on that. In relation to Bonnie's comment about section R1 with the surgery room doors, it was the feeling of the task force that there would not be an instance in which a horse would be receiving surgery at an animal shelter. So what it says in section 2030G5 is that if the size of the animal prevents the entrance to the room from an internal door, such as a horse, then you can have doors going to the outside, and that's what allows, you know, big equine surgery facilities to have those doors. The task force said, when is that ever going to happen? So Dr. Drusies may have an opinion about that, but I wanted to let you know that's why that language was altered in some way to be a little bit more specific to an animal shelter.
Certainly in animal shelters, we would not be in a position to be plating fractures, doing essentially clean surgery. But as I joke with staff all the time, if I go out back, knock down a horse and castrate him, I come back to the clinic and say, on a weight basis, I've done more today than you guys have. So yes, some of us do surgery, but we call it Jurassic Park. It's out of it's on the perimeter of the Riverside shelter where I do routine castrations all the time. But it's the same as I did, the same circumstances I did as an equine practitioner 20 years ago.
I just have a couple of follow-up comments. On the husbandry standards, I still see that as a problem because I don't know as a lawyer where I would look for that. I mean, I don't really know anybody that I would even be able to call and say, what did you mean by husbandry standards? So that's really my problem looking at it from that point of view. As far as the clarification, Dr. Miller just made a good clarification. My recommendation on R5 would be to just end it at outside the facility and take out when aseptic surgery services are provided so that that doesn't give somebody the opportunity to have that opening door open when they're not performing aseptic surgeries. And just don't use that last part of the sentence. Just say that you can't have an opening door, period.
If you want that in there, can't you just change when to where?
That would work too. Yeah, it's just the when is my problem. Is that, you know, because when implies time.
On the, you know, although Bonnie's comments are very well thought out and excellent points, on the first page of the memo there's hyperlinks to 4 different webcasts, and those were not 15-minute conversations that the MDC committee had. Each of those webcasts are about, 3 hours, 4 hours, where there was many stakeholders in the room that were truly agonizing over every single word and line of this document. And I admire Dr. Miller's ability to recall specific reasonings behind why the language is what it is. But I think that there probably is a reason why it's presented as such, and I wouldn't be in favor of any changes.
I would, if you look at R again, it says that the beginning of that says, if aseptic surgery is performed. So do you really need that last part of that sentence at all, whether it's where or when? Because all of those numbers 1 through whatever are prefaced by if aseptic surgery is performed. So again, I would just recommend that, You know, you take out that everything after outside the facility because it doesn't add, it's not adding anything and it's potentially causing confusion.
Dr. Drusis.
Yes, relative to that, I think it's my recollection that we lifted this provision directly from the small animal hospital provision. Most of the time, what goes on in shelters from an aseptic surgery standpoint are spays and neuters and maybe an occasional amputation. So most of us felt that the provisions that were required for a small animal clinic hospital should also pertain to an animal shelter where identical procedures are being performed.
Thank you. Any other comments? Dr. Nunez.
So if you change it here, you would have to change it there.
Do I have a motion? Oh, Tara wants to. Yes, Tara.
I just wanted to add also R4, the surgical room. We need to change surgical to surgery for consistency with that, the use of that term.
Surgery. So is that one of two changes? I also like the does instead of does not.
Thank you. Would you also be amenable to adding surgery on R1 between A and a room, like a surgery room?
I would be amenable to that. And I have a tendency to agree with Ms. Lutz where she said that in R5, deleting at the end of that sentence, when aseptic surgery services are provided, I think that, I do think it is redundant because that subsection begins with if aseptic surgery is performed.
So we have two options there, change the when to where, or remove the last few words.
Right.
1, 2, 6 words. Is there a consensus on that? Remove it. Remove the last 6 words. So it looks like we have 4 amendments. Shall I read them off so you're aware of them?
Yes.
It looks like a public comment.
Just to complicate things a little bit more.
Go ahead and introduce yourself.
I'm Nancy Ehrlich, Harptet. You've already discussed this, but I agree with the comment about the duties of the supervising veterinarian under Animal Healthcare Task for RVT, that under G is the only one that doesn't specify who may administer the particular treatment. So I think it's confusing, and it should say whether RVT, veterinary assistant, VA, CSP holder, whatever you want to put in there, but it should delineate which person is eligible to do this.
I went down that road and I got shot down there, Nancy.
But you were correct, because every other one does specify who can do it. So then you get down there and you go, well, wait a minute, by whom?
I think the comment was made that it actually is addressed up at CCR section 2035.5 on the prior page.
Yeah, but then why is it specified in every other subsection? I don't think it's clear.
You're right, it is specified.
And in every other subsection, it isn't always all the people. Some tasks are limited to RVT, some tasks may be done by veterinary assistants as well. So when you get down to administering a rabies vaccine, it becomes confusing as to who can do it.
Tara, do you see what she's saying? It's specified.
Yeah, I see what you're saying. Because the subsection we're looking at, G, is separate and apart from A. It's not part of A. So, yeah, we could add an RVT, VA, CSP holder, or veterinary assistant if the members want to include all three of those individuals. May administer rabies vaccines to an owned animal upon redemption.
Because we don't want the cat doing it.
If you can do it.
So the question is, do the members agree that RVTs, VA CSP holders, and VAs should be able to, in a shelter setting, administer rabies vaccines to an owned animal?
Yes, we're just inserting it as we did before in other subsections. I'm okay with that. Okay, that makes 5. Nancy. Did you have a statement, Nancy, or question?
No, I didn't.
Oh,
I'm sorry.
Any other public comment? Oh, Kathy, I'm sorry. I do this all
Yeah, I'm sorry. That's the first time I've done it.
Okay, shall I read the 5 changes? The first would be in subsection R1, inserting surgery between the first word A and the second word room. And then down in R4, changing the word surgical to surgery, the surgery room. Then in 5, we will remove the last 6 words, when aseptic surgery services are provided. Then in S, we are changing the word do to does on the second to the last line. Does not warrant the use. And then the last change would be to insert after the word administered, we would insert by an RVT, VAC, SP holder, or veterinary assistant. To, and then it would be to an owned animal. Any other changes? Did I get them all? Yes, Dr. Miller.
So it's a change to a change. So under S1, the word do.
At least I didn't call you, Bruce or something.
Tara, you might have to take a look at this. So the word do corresponds to circumstances. So it's circumstances that do not warrant the use of aseptic surgical procedures.
I agree.
Yeah.
We can't be in grammar.
But it's really referring to performance of a surgical procedure. I don't agree. It's referring to the performance of a surgical procedure, and then for the treatment and under circumstances. But it really is referring back to it's referring back to the performance of a surgical procedure. Do you agree with me? Or am I wrong? I'm not an English major, so.
It looks like circumstances.
I think it's circumstances.
Because it's referring to the performance for the treatment and under circumstances, but it really is referring back to the performance.
Is there a DCA grammar council?
I don't know.
So correct me if I'm wrong, but if we adopt these rules, doesn't it give you the authority to make non-substantive changes?
Great, so I'll just back off and there you go. Okay, so delete that from the motion, and you guys can figure it out. Are we ready for the motion to be read? Okay,
Yes.
thank you.
The motion is to approve the proposed regulatory changes as modified, direct the executive officer to take all steps necessary to initiate the rulemaking process, authorize the executive officer to make any technical or non-substantive changes to the rulemaking package, notice the proposed text for a 45-day comment period, and if no adverse comments are received during the 45-day comment period and no hearing is requested, adopt the proposed regulatory changes as modified.
So moved.
Second.
Okay, we have a motion and a second. Call for the vote.
Public comment.
Oh, I'm sorry, more public comment from anyone? Call for the vote.
Ms. Bowler,
Aye.
Dr. Bradbury,
Yes.
Ms. Laredo,
Yes.
Dr. Nunez,
Yes.
Dr. Waterhouse,
Yes.
Ms. Yanis,
Yes.
Dr. Nolan.
Yes.
Motion carries.
Motion carried.
Okay. And
I think we need a break.
yes. And Dr. Pollard, one thing I learned as president: never say something's going to be quick and easy.
Okay, I think we're going to go ahead and. Oh, yes, Dr. Drusis.
At the risk of getting my wrist slapped by legal counsel, I had suggested over time that perhaps at lunch or slightly thereafter, the Riverside County Department of Animal Services would welcome the Veterinary Medical Board and VMB staff for a quick tour of the Riverside shelter. Is that still a consideration?
Yes, I would be excited to do that, and I think there would be other takers.
Okay, so
Today at lunch.
I would just quickly need to know if we would need to provide some transportation to the shelter, and I can have staff arrange that, and I would need a time.
We can discuss it during the break.
Okay.
So we'll take a 10-minute break. I have a couple of housekeeping issues. It looks like I would like to announce that items number 13, 14, and 15 are on our agenda today, are going to be rolled into tomorrow's meeting, tomorrow morning. That would be items 13, 14, and 15. We are going to try to get to 16 if we can. Also, we're going to attempt to get through item number 7 and then break for lunch. So, having said that, we had very impressive qualified candidates, 5 applications for the vacancy on the MDC board, and the executive committee, including our EO, did preliminary interviews and actually we were very impressed with the quality of all of the applicants. We did narrow it down to 2 candidates who have come before the board today for further interviews for the whole board to interact with them, and the board has questions in front of them to ask the candidates. I think we can just go in order. So if when we have the candidates in front of us, we can just start with Alana and we can move our way. And having said that, is there an order we need? Okay, so maybe Dr. Sullivan, would you like to step forward? And would you like to just introduce yourself quickly and give us a small synopsis of your background?
Dick Sullivan. I'm a small animal practitioner in Southern California in Torrance. Have been practicing there for many years. I'm not sure I want to tell you how many, but it's been a long time. Prior to that, I graduated from Purdue University and spent 2 years in the Peace Corps. Came back to the States and became an associate in a practice in Madison, Wisconsin, and then moved to Los Angeles. Connie and I were coming out here for 4 or 5 years as she got her doctorate at UCLA in epidemiology, and 40 plus years later, we're still here. So that's pretty much my background in veterinary medicine. I've been active in organized veterinary medicine most of the years in California. Presently, I'm the delegate for CVMA to the AVMA, House of Delegates, and work on various committees. And I'm also on a policy task force for the American Association of Veterinary State Boards. And the issue that my subcommittee is working on is cannabis. So very relevant.
Thank you. We'll go ahead and start our questions.
What is your understanding of a licensing board's functions?
Licensing boards, their main function is consumer protection. And they do it by overseeing the licensing and any enforcement of any disciplinary action that it comes from the public. They also set regulations based upon whatever statutes allow them to formulate regulations under a given statute.
What do you believe the MDC's role is in fulfilling the board's consumer protection mandate?
Well, the MDC is I see it as the kind of the grunt work for the board. They hold the meetings, they get the stakeholders present, they research in great depth what the issues are, and do that type of work to get a product to the board that the board then can fine-tune. So it's mainly regulatory issues. In the case of cannabis, it's guidelines, but it's that type of work. It's doing the background work and getting the hearings where the public can have, the stakeholders can have input.
What do you believe are the top 3 issues facing the MDC?
Well, the 2 that we're looking at right now are the Cannabis Guidelines and corporate ownership. The third, I would probably have to be creating one. Personally, I have great concern over the lack of movement of our regulatory issues through the process of Office of Administrative Law. I would like to see us tackle that. It would be stepping on toes, but sometimes that's what you have to do. The Brazilians have a great saying, "Kinky now, now I can't say it. Kinky now, chora now mama," which is the baby that doesn't cry doesn't nurse. And I think sometimes we have to step on toes and get some things done. I'm just surprised at that slow process, and I think we may need to work with other boards and see if the process can't be streamlined.
What strengths do you bring to the MDC that other candidates may not have?
Well, first, I have institutional memory. I think that's important on our MDC because it is a relatively young group of members, and before I got on to the Veterinary Medical Board, I was on the MDC for a little over 2 years, and while I was on the board for 6 years plus, I was also the veterinarian that was assigned to the MDC. I do my homework. I come prepared, and in addition to that, when something doesn't make sense, I do my own research. And I think a good example is when we were dealing with telehealth, and we kept hearing, well, if pediatricians can establish a relationship with a patient with a virtual exam, why can't veterinarians? It didn't quite make sense, so I joined the American Telehealth Association, non-dues member, but it's an association that sets up guidelines for the different disciplines in medicine, and I looked up the guidelines for pediatricians, and right in there it says any infant under 2 years of age should have a in-person examination. It should not be established virtually. So I enjoy doing this kind of work. I think there are people that think I'm crazy enjoying doing regulatory stuff, but I do, and I like working with the staff, and I think that I can bring some practicality to the regulations. We can get terrific ideas and mandates from the legislature, but if we don't implement it practically, it can't be done. So I think I bring that to the MDC also.
Dr. Sullivan, why are you interested in serving on the MDC?
Well, I think I've explained it. I enjoy the work, and I think the group is really important and really interesting topics. And if we did enjoy what we were doing, we wouldn't be doing it.
Dr. Sullivan, hi. I actually think this is the question I've got is a very important one, since so much of what we do is about this, and we all are volunteers after all. What experience do you have in researching, and I think you've covered some of this, or writing regulations, legislation, or other regulatory policy?
The 8 years on the MDC and the 6 years on the board exposed me to looking at statutes that then allow us to write regulations. I've been able to testify a couple of times at the legislature, and definitely the process of working with legislators on every issue is really critical. I use the phrase all the time, if you're not at the table, you're going to be on the menu, and I think we as the public and we as the profession need to be engaged in this process. That's how we are able to do the job that we are assigned, which is consumer protection.
So, Dr. Sullivan, the MDC considers controversial topics that can get contentious, as you know. What is your experience negotiating various viewpoints in order to make the final decisions or recommendations?
There's well, first of all, I think committees are extremely interesting. When I get on a committee, whether it's CVMA, AVMA, the Veterinary Medical Board, the MDC, the first thing I look at is the dynamics of the players. And I find that as a science in of itself, and who comes prepared, who does the background work, and who I need to convince that I'm right. Unfortunately, that doesn't always happen. But I think it's the give and take and the sometimes somewhat heated conversations that we need to have to get to a point of what serves the public the best. And if I can't argue my point and prove my point, then right away I decide the other issue or the other comments have taken the day. And once I leave that room, I'm committed to what the majority has ruled on and voted on. And then it's time to go have some refreshments and find out what other people's families are doing and what vacations they're taking, and enjoy the working with the people at a different level.
Perfect, thank you.
Do you have any final comments you'd like to make to the board?
No, I was a little more nervous than I thought I was going to be, but thank you for the opportunity to do the interview.
Thank you, Dr. Sullivan. The next candidate is Dr. Jamie Payton, and we'll have her come on up and answer some questions. Welcome, Dr. Payton. Do you have any, would you like to introduce just a brief synopsis of your background and who you are?
Sure. Well, thank you so much. I'm so honored to be here, and especially against an amazing Dr. Sullivan who has so much experience. So I'm very honored. My name is Jamie Payton. I am a veterinarian. I'm board certified in emergency and critical care. My background is I went to veterinary school at the University of I'm programmed to say California now, University of Florida. And then I went on to Texas A&M for my internship in small animal surgery and medicine, and then came to University of California, Davis for my residency in small animal emergency and critical care. After finishing my residency there, I went into private practice and was at a multi-specialty clinic. Actually was at 2 different ones, as well as doing relief and emergency. Set up 2 different emergency and ICUs in those settings, and ran a renal transplant program for animals as well. And then decided to go back to academia to start the integrative medicine program, which was very exciting. And I have been there now for 5 years and developed that program where I teach 4th year students, as well as some of our 1st through 3rd year with our mentoring, the Integrative Medicine Club.
Great, thank you. Alana.
What is your understanding of a licensing board's function?
So that's a really great question, because I think it's very important. Oh, of course. I have a soft voice, so thank you for telling me. Really, the function of a licensing board is, one, to ensure that the people that are applying for the license are qualified and have the knowledge and to be able to perform the job, and especially to uphold the Veterinary Practice Act, as well as ensuring that the licensees are responsible and follow that act as they go along.
Hi, Dr. Payton.
Hello.
So what do you believe the MDC's role is in fulfilling the board's consumer protection mandate?
So the role of the MDC is, from what I can see, is really exploring the issues. And that's what I find very exciting and compelling about the committee, is that it is an opportunity to explore those issues on a deeper level, gathering all the information from different sides, all the details, and really taking that time to hash it out and come to a overwhelming or overview of the issue from all sides. Sometimes that's 2, sometimes that's 5, but I think it's a really good opportunity to look into it more in depth, and then come back to the board with recommendations and have a bigger picture of what's going on.
What do you believe are the top 3 issues facing the MDC?
So right now, I think, looking, you can read in the media and everything that's going on. I do think that the cannabis issue is very important right now. It's because of the knowledge in the public as well as in the veterinary community. Having been here and listening to everything, I think that the issue of course, with corporate medicine is also such a big topic, and I think that one really needs a lot of investigation from multiple different sides and multiple different views. The third issue, I think, is kind of more not as specific, when we look at the blood bank issue as well as the decline, is more of the issues looking at pet or animal welfare, but also in light of veterinary medicine and what in a bigger picture, because I think that those are have different views from different sides. But I think it's really important that we look at those issues.
What strengths do you bring to the MDC that other candidates may not have?
Sure, I think it's interesting for me with sort of the diversity of my background. I have worked with so many different teams and made up of all different people with different backgrounds. And being in private practice and having that experience building 2 services in private practice, but then also now having been in academia, both as a resident and now as a faculty member, and having those experiences and different viewpoints, I think really is something that I can bring to the table on the committee, all those different views, and especially, looking at the next generation of licensees. I experience that every day, and the students are very important to me.
Dr. Payton, why are you interested in serving on the MDC?
So for the past couple years, I've been very fortunate to have been involved in a couple of the issues, the animal rehabilitation, the cannabis that I have a personal interest in from my research. And, that really, those experiences coming to the Vet Med board meetings and talking with all different sides has really inspired me, the role of regulatory committees and boards in helping the issues that affect my patients as well as their families and the community as a whole. And I feel that my experience and different viewpoint could really bring something to the committee, and I'm excited to be a part of that. I think that's really why I'm interested in it.
And then, hi, Dr. Payton.
Hello.
Sorry. What experience do you have in researching or writing regulations, legislation, or regulatory policy?
So I think, looking at that issue, that is probably where I am weaker because I haven't done a lot of work at regulatory issues at this level. I have a lot of experience in research in general and how to go about that, being in an academic environment. So a lot of experience, looking at issues myself, delving into them, but also gathering the details from all the different areas and viewpoints. I will say that developing policy and regulatory issues are something that we see a lot of both in private practice and in academia. But I am really eager to take those experiences and learn more from being on a committee with other team members that may have more experience than myself.
So, Dr. Payton, I'm sure you know the MDC considers controversial topics that can get contentious. So what is your experience negotiating various viewpoints in order to make the final decisions or recommendations?
So my experience in dealing with controversial topics, I guess I'll start out with, I started an integrative medicine program at the #1 vet school. So I think that we've had a lot of topics that have been quite controversial. And I have to say I embrace that because I think that it's very important to, again, look at all the details and have a critical problem-solving approach to looking at these controversial issues. And one of the things that I think that I bring to the table is I really enjoy listening to people. And that has helped me in the past with controversial issues, is taking the time to listen to what everyone has to say and hear the details of what they're saying. Because sometimes people say a lot, but it's really core things that they're asking for. And then putting that all together with a broad view that I think will address the issue, but also try to make it an issue that everyone can agree on for the most part and working on moving forward.
Okay, thank you.
Thank you, Dr. Payton. Would you have any closing comments for us?
No, like I said, I really appreciate being considered. I think that a regulatory committee is so important to what we're doing. I'm so passionate about as I said, my patients and their owners and the community, and ensuring that we really delve into these issues. And I think that the MDC is an excellent way to kind of bring my past experience with being in different roles to the committee and move forward. So thank you very much.
Thank you very much. So As we know, item number 7 on the agenda is the election of a veterinary member to the Multidisciplinary Advisory Committee, and nominations are open for the position of veterinarian member of the MDC.
Are there any nominations from the board?
I nominate Dr. Sullivan.
A motion has been made to nominate Dr. Sullivan.
Could I ask a timing question or scheduling
Sure.
question just on the MDC because I can't recall? When is the next opening up? Is there another opening up in the near future? I don't remember the.
It seems like
cycling
there's
off.
always an opening coming up at some point, so I'm not sure the exact time.
I could look into. I don't know that.
Okay, all right. Just because we've been given 2 terrific candidates, can't we just add a? No.
The
Okay.
intention was once every 2 years. We said
Was that it?
wasn't
Okay.
Any further nominations for the MDC veterinarian member?
Did he get a second? Did Dr. Sullivan get a second? Or?
Doesn't ask for a second. My notes don't require a second.
Okay.
So after nomination, according to our script, we have discussion by board members, and then there'll be a formal motion after that from the board members.
So this is not a motion, this is a nomination.
Okay.
So in order to discuss this, we have to nominate. So I would nominate Dr. Payton.
Thank you.
So now, is there any discussion by the board members on the candidates?
Now we can open it up to discussion.
I
Would you like to start on one end and work our way across, or?
So talk about 2 extremely well qualified candidates. I'm very sad that there's only one position. They both bring a lot to the table, so I don't think we can go wrong with either candidate. But with Dr. Sullivan's institutional memory, I think that's something that's badly needed on the MDC.
Ms. Bowler.
Yeah, I was going to say that too. I mean, I'm thrilled that Dr. Payton's interested too. But I do think there are a lot of new members of the MDC, and that Dr. Sullivan, because of the last few years and all these topics that have not gone away are still around, I think he will help the MDC right now just because of his background and everything and the memory.
Yeah, this is more difficult than deciding which baker leaves on the Great British Baking Show because they're all so good. But I believe that there's unfinished business that Dr. Sullivan has a world of knowledge to bring. I noticed on the memo there's hyperlinks to their licenses, so I did check that out, and both of the candidates check out.
Well, I was really sincerely thrilled at the depth of applicants, and I think it speaks well for our profession and their willingness to step up and volunteer and their commitment. And I appreciate both of these final candidates and their dedication to the public service proponent of the profession. And I think they would both bring different skill sets to the MDC, but I think I do agree with the comments made earlier that at this point there are some issues that, as Dr. Sullivan mentioned, his historical knowledge it would play a very important role. So.
And I have to echo the same sentiments that both candidates are fantastic. I think they're both would do well. But with Dr. Sullivan's institutional knowledge and some of the topics that we're debating right now, I think Dr. Sullivan would do well there.
So being new to the board, I am not ever attending an MDC meeting. I don't think that I quite understand the how young that group is, and it makes sense what you guys are saying about the experience. I know that Dr. Payton is a fantastic candidate as well. I was sort of excited to see some new blood that applying. But it does sound like it makes sense at this time to have somebody with that kind of experience that Dr. Sullivan brings on that committee. But I do hope that Dr. Payton considers a future application if Dr. Sullivan gets nominated.
Yeah, I think I heard Jennifer say it one time. If you don't get in on the first try again, because then you usually get in, right? So I think Jessica just said we have some availability for new MDC members in 2020. So I would definitely encourage Dr. Payton to reapply when those come up. But institutional memory is important. I understand that its importance, having served on a commission for the city of Los Angeles for almost 5 years. We had Richard Riordan's daughter who had been on the commission for, I think, over 15 years, 20 years. And her institutional knowledge for our board was critical. So there is no denying that. So I think Dr. Sullivan absolutely brings that to the table, and especially if there's some issues that have not quite been cleared up. I am new to this board as well, so I believe my colleagues when they say that. So it would be good to see those issues move forward. So I probably would defer to Dr. Sullivan as well.
Okay, thank you. May I have a motion?
I move that we appoint Dr. Sullivan to the MDC.
I second.
Thank you. Public comment, please. Anyone would like to come up and have public comment? Okay, I'd like to call for the roll call.
Ms. Bowler,
Yes.
Dr. Bradbury,
Yes.
Ms. Laredo,
Yes.
Dr. Nunez,
Yes.
Dr. Waterhouse,
Yes.
Ms. Yanis,
Yes.
Dr. Noland.
Yes.
Motion carries. Congratulations, Dr. Sullivan.
And again, thank you to Dr. Payton. We really appreciate her interest, and we encourage you to come back.
Yes, please.
Okay, we'd like to go ahead and take a break for lunch. We will return at 1:30. Next on the agenda is item number 8, update, discussion, and possible board action on 2019 legislation. I'm going to turn the floor over to our EO.
All right. So it's been a fun session so far. Just a quick note. In the packet, I do say that we're no longer going to be printing the legislation as legislation changes quickly. Sizes change, analysis are added. And so we provided hyperlinks to all of those documents. And so we highly encourage everybody to use that document more of a resource to access all the information that is added, because as you'll see, more information happened since the creation of this memo. So quickly with A, it's update on pet cremation and legislative proposal. We did, after this board meeting, staff and legal counsel met with DCA and CFB, and we talked about the issues that are before us. CFB also testified during their sunset hearing that they are willing to work with DCA and the board to research this issue and propose solutions at a later time. But I think from everybody involved right now, there's a lot more questions than answers at this time. It's definitely something worth looking into. So I don't think this is going away. It's just right now DCA is committed to working with all stakeholders to identify the issues and the appropriate actions. So right now we're going to spend the next year gathering more information and developing a solution, and I believe that DCA will be facilitating all of that, so I can keep you apprised as that moves forward. But I don't anticipate any legislation addressing this issue this session. Any questions with that one?
I think did I hear a rumor that there is some bill that they got on not regulating, that hasn't gone forward. I thought there was some animal cremation.
No legislation to my knowledge,
Okay.
but it was mentioned as part of the sunset review for CFB, Cemetery Funeral Bureau, and so it was mentioned during the legislative hearing, but there's no legislation dealing specifically with this issue at this time.
I'm disappointed that the CFB doesn't want to take this issue up with as much alacrity as I would like them to, because I think it's an important issue.
Yeah, I do too.
And I don't know if there's any way we could encourage them to do so and still remain a big happy family under the DCA umbrella.
So, and I don't think that they're unwilling at this time. I think they have a brand new bureau chief, and they want to be responsive and thoroughly research the issue before they push forward with legislation. So I don't think that they're unwilling. It's just they want more information. All right. So let's get started. AB 312. This is Cooley, the State Government Administrative Regulations. This was in response to Little Hoover Commission's 2011 report entitled Better Regulation Improving California Rulemaking Process. And I think while we can all agree that that process needs improvement, I have some concerns with how this bill is trying to address that. This bill would require each state agency before January 1st, 2022 to review all of our regulations and identify any outdated regulations, and it's a huge undertaking. There was an analysis added since the creation of this memo by Assembly Appropriations. They said for OAL to implement it, it would be $2 million. In addition, they think that, it's unknown how much from general and special funds, they do believe that it's significant aggregate costs, likely millions of dollars, over $10 million from general and special funds to implement. So right now it's in suspense, but it's very costly. I think that there are, the Little Hoover Commission's recommendation was to establish a mechanism to do a look back on your regulations. I think that mechanism is us. That's my job. That's the board's job. And I think it's also part of sunset if there's concerns that we're not doing our job appropriately. That's also up to the sunset to hold us accountable to that. I think I can tell you that I am devoted already to looking at our statutes and regulations. I think there's a lot of room for improvement, but putting this deadline on it, I think, is unrealistic. So I'm committed to doing this, just I can't commit to that timeline. So at this point, I think that this bill is not necessary, and I think it's way too costly. Any questions or comments or potential positions?
I assume that DCA, in general, the other boards are in the same mind.
So I actually don't know that yet. I have not received any information from DCA, and I was not in attendance in their DCA legislative roundtable. I hate to put Moniel on the spot. I know you were at the roundtable. Did DCA speak to this bill at all? No.
Was this done before? I seem to remember this was already done.
Yeah, so this has been tried a couple times and has been unsuccessful due extremely to the cost. So I think that it'll keep trying to come back, but the costs aren't going to be reduced.
I think it was something that was a potential item for sunset last time we went through, but then it was dropped and we didn't have to do it because of the reasons you said.
Yeah.
How long can it be? How long can the proverbial can be kicked down the road, though, before we have to do this?
I think through Sunset we can identify what we're doing to meet the intent of the bill. Whether we won't have a set time frame, but we can identify the statutes and regulation that we're looking at. I can tell you I already have a laundry list of things that we need to address. But we also have a lot of other things. So it's a matter of prioritizing our workload. But it's something that we can let the legislator know that we're committed to doing.
Yeah, I think it's something we should do. I wouldn't put it at the bottom of our priority list, but
yeah,
we have a lot to do right now.
Mm-hmm.
Dr. Bradbury.
Yes, so I wanted to say I support your stance because you asked for our opinion, and I like the idea of us working on it anyway, since it will eventually probably go through at some point, and if we've already gotten a lot of the work done over time, hopefully it won't be in this time frame, and you could just hand that over to him.
So the board we can continue to watch it and bring updates, or you can take a position on it.
Ms. Bowler, would it be appropriate to move to watch it right now without taking position one way or the other?
Is that a motion to watch this bill?
Yeah.
Is there a second?
I'll second it.
Thank you, Ms. Yanez. Call the roll.
Ms. Bowler? Public comment? Oh, sorry, public comment?
Oh, and any public comment? Thank you.
Ms. Bowler?
Yes.
Dr. Bradbury?
I'll abstain.
Ms. Laredo?
Yes.
Dr. Nunez?
Yes.
Dr. Waterhouse?
Yes.
Ms. Yanez?
Yes.
Dr. Nolan?
Yes.
Motion carries.
I have
Yes.
one more thought.
Yes, Dr. Nunez.
Could it, since it is a monumental task, could it be an issue that is referred to MDC to start some work on it?
Yes, you can do that.
I think that's a good place to start. Can we go back an item or two on the agenda for a task for the MDC committee and task this to them?
I believe so. I don't see why not.
May I, the council, go back agenda items?
Well, I think throughout the meeting you can assign tasks to the MDC. You don't have to wait for that item.
Then I move that we assign the task of reviewing our current regulations and identify any regulations that are duplicative, overlapping, inconsistent, or out of date.
I second that.
Public comment? Yes.
I'm sorry, can I just ask a question? Yeah. How many things are on the MDC's list right now? I just am wondering their time in terms of on a Tuesday, how much they can get through.
So there's three, two from the board, the corporate practice discussion and the cannabis guidelines, and then also with the MGL and the application for the premise registration. So yes. There's three.
And how are we doing getting through those items when we're having those meetings? Are we getting to what we need to get to, or are we putting things off each time? I kind of see different looks, so I'm wondering. Because I'm not there, I'm sorry.
Dr. Sullivan's going to be on the NBC, so we'll let him do that.
Yeah, okay. We appointed a young hotshot veterinarian who can handle it all.
Okay, I just wondered. Thank you.
Any other comments? Call for the vote.
Ms. Bowler?
Yes.
Dr. Bradbury?
Yes.
Ms. Laredo?
Yes.
Dr. Nunez?
Yes.
Dr. Waterhouse?
Yes.
Ms. Yanez?
Yes.
Dr. Noland?
Yes.
Motion carries. All right. AB 366. This is related to animal blood banks, blood components, and biologics. The hearing has been postponed and then later canceled, and it's now set for the 25th. It is still in assembly right now. The bill, essentially after January 1, 2020, would eliminate the closed colony model for blood banks. There's been a number of concerns raised, and I provided all members, and there's copies in the back of a letter of concern that the executive committee, which is Dr. Waterhouse and Dr. Noland, has raised in relation to the bill. And so with that, I'd like to turn it over to the executive committee if you want to go into any more detail with the concerns.
I'll speak to this. I was the one selected to kind of do the research on this topic, and I have learned a lot about blood banking. So we had four main concerns, and one was the safety of the products that were produced. Two was meeting the volume of the volume of the blood products that is needed out there. Three, the production and availability of all the blood component products. And for the environment of the donor dogs. Many places, UC Davis, for instance, they do have colonies for cats, horses, cows, and llamas, if I remember right. But they do have a community blood bank of dogs. There are, as we learned, 68 different community-based blood banking across the country. And so I've talked to at least a dozen different people about this. And so I do have concerns about eliminating the colonies totally. There's, from everybody I've talked to, there is a great concern about just meeting the volume that is needed. Dr. Bradbury can probably speak to that. And also the availability of all the blood component products. Even UC Davis, as advanced as they are, they're one of the top two community blood banks in the country, the other one being Penn, I think. And they still, the emergency clinicians at Davis still have to buy one blood component product from a commercial lab, one they can't get at UC Davis at the community. And so anyway, there's great concern about this bill. There are two colony-based dog colonies in California, one at Hemopet and one in Northern California. And I think there's a representative here from ABRI that can probably speak to this too. But I did call and talk to one of the community blood banks in Iowa, because I'm from Iowa, so I recognize one of the little pinpoints on the map. And at Iowa State, they do have at the veterinary school, they do have a community-based blood bank. They only have 10 dogs. They're always in need. They don't sell to any outside clinics, any other hospitals. They're always in need of blood. And they did have one dog that had tested originally negative for everything, had made several donations, and that at a later testing date showed up with anaplasmosis. And so they had to go back to all those recipient dogs and trace that back. So anyway, that's kind of my summary of, there's one other aspect of this that I learned, that there are blood component products that are come from other manufacturing places outside of California that produce products that they cannot ship into California. So there are products that veterinarians, especially critical care specialists, internists, can't use in California. So this isn't part of the bill, but I would like to see a part of the bill that any USDA sanctioned or USDA produced product that's made outside of California should be allowed to be used in California. Yeah. Would you, Dr. Bradbury, can you speak to that?
Yeah, there's, I think there's two products that I can think of. One is canine albumin, which right now we're using human albumin, which isn't ideal when patients are low in protein. and some people would say is not a good idea, but it's the only product we have. And there's a lyophilized platelet product that we can have that would come from somewhere else and be stored on the shelves, and we'd be able to use it. I can say that we run out of blood, I wouldn't say every week, but it's not infrequent that we are trying to get more blood for our patients that are in the hospital. And so I think anything that's limiting that is a concern for the consumer and for the patient. And I agree with you. I have been wondering why we don't allow these products that are okay elsewhere to be shipped into California, and what that is actually protecting.
So in my research of that, the reason is because that CDFA, who oversees all the blood banks in California, doesn't have the regulatory ability or probably the funding to go inspect the facilities outside of California. So it's kind of a bureaucratic thing, but I would hope that anything that's USDA produced would be okay.
Yeah, we can get drugs from other places.
Yes, yeah.
Any other comments from the board? I have some, but I thought, are we going to go to public comment too?
We will, as soon as.
Oh, yeah. I just said, I learned a lot on the blood banking situation in California too. And as a huge dog and cat owner, obviously I don't want to ever do anything to hinder the supply. But the state of our law in California on that is so arcane. The fact that vets can't buy from out of state, that they must only buy from the 2 closed colonies, that you've got a community colony in Davis, I think, that sometimes has to throw product away because nobody can buy from them. It just seems like we are behind the times, and we do need to modernize. I do have concerns about the closed colonies, health and welfare of the donor dogs, that's for sure. But I really think we have to look at. I didn't realize that as consumers, and vets were so limited in what they could do, and I just think that's stupid.
Yeah, Dr. Bradbury.
I'm not really sure what the language of the law is, but I think there's also some restrictions on us, like having our own community, or I guess not a community, closed blood donor group. But we used to have clients that would, bring in their dogs. We provide them with heartworm prevention and flea and tick control, and do testing on them frequently, and they would allow their dogs to donate, and we would be able to use them in a pinch. And we can't do that anymore because of, I believe, a newer law that came into effect a few years ago, and I'm not sure if it's a regulation or a law. I don't know. Do you know what I'm talking about? Have you?
So last year there was a bill to allow veterinarians to use their in-hospital dogs or clients' dogs, their dogs.
Because
that
we
did
all
allow.
I think
But
everybody just stopped doing
you
that.
You may have more of a community-based.
I see.
Because it was kind of owned by clients, and it might have sort of been defined as a community-based.
We had to stop doing that. So in any case, it really has limited us, and in some cases, when the local blood bank doesn't have any more blood, I could find it in other states, but we just can't ship it in.
Yeah. Jennifer.
So I didn't realize what an issue this was. Back in the late 90s when I was working in a day practice, the staff would bring in a pet to be a blood donor, and we were offered some compensation. It was a smaller practice, so I didn't realize how big of an issue this was. So it's definitely not my area of expertise, but good information.
One other thing is that everybody I talked to was short of blood. And it's my understanding the 2 closed colonies in California are like 6 weeks behind in their orders. Everybody I talk to says, don't do anything to mess up the shortage of blood.
So this, I want to see if I understand this correctly. This bill is going to prohibit the existence of these closed colonies that currently are in place, but they are going to allow for what I'm going to call collective colonies.
Community colonies.
Community colonies. But they have to be licensed by the Food and Agriculture, and they also have to be under direct supervision of a licensed veterinarian or board certified specialist. And it's not defined which certification they're looking for.
That's one of the little problems there, yes.
And it can't be, you can't charge for it. Is that correct?
Correct.
Wait, vets couldn't buy from the community colonies?
It would prohibit
You can't pay the client.
You can't pay the donor.
Right.
Yeah, or you can't pay the donor.
And there's one other issue, and that is the timing and thoroughness of the testing is not really laid out on those community donors.
There's a concern about the testing.
Yes.
And
the
quality of
time frame.
product from the
Yes.
collective colonies.
Yeah, so the minimum is many of them are testing once a year. Some were testing every 6 months.
And those are standards that
community.
are established by the Food and Ag. How
I don't know
frequently they need
that.
to test?
I don't know. There's an ACVIM consensus statement which lays out which diseases should be tested for. There's 20, and I didn't talk to Hemopad, but I talked to the other, the one in Northern California, and they say they go beyond what the consensus statement recommends.
Those are the current closed colonies.
That's the closed colony, yes.
Whose
The
role-
community ones they vary. So many of them, UC Davis was testing once a year. The one in Iowa was testing every 6 months.
So the current closed colonies are under the rules established by the Food and Ag.
Yes.
But they go above and beyond the requirements that Food and Ag says.
ABRI said they were going above those, yes.
To USDA?
Yes.
And so the reasoning behind this bill is not to make the final product better for the consumer,
No.
but to just stop animals being kept in a closed facility for the sole purpose of
That's
as.
my understanding of the intent.
And these closed colonies, the donors don't live there forever. They have
No.
a certain lifetime.
Yes, they spend some time my understanding is they spend some time in the colony. They and again, I've talked to many different people, but in general, what happens with the closed colonies is they take dogs that would otherwise be euthanized and bring them into the colony. They're sort of given a job then, but they get socialized, they get trainers, they get, many places have volunteers to come in and walk them, to take them, give them socialization, and they make them into dogs that can be adopted eventually. And they may spend 1, 2, maybe 3 years, I think I've heard at the most, in these closed colonies, and then they go have a home.
So, in the interest of consumer protection, I think that the board probably should focus on not changing this current system, but help in some way to expand it because of the backlog that you mentioned. These closed
Yes.
colonies have a backlog.
They produce the vast bulk of the blood volume.
And so this bill would not accomplish that.
This, as one of the criticalists at Davis said, this bill is a step backwards.
Yeah, the one thing I disagree a little bit with Mark. I know it has an end date in this particular bill, and we're going to be talking about 2 pieces of legislation here on the same subject. The fundamental thing is right now, community colonies are not allowed in California. That's it. So this bill would allow them in California. Obviously, then the structure, regulation, and oversight of those colonies would be left to a future. I mean, I don't know if the bill contains that right now or if that would be left to regulation, but obviously from our perspective, from mine, I'd want to have as much oversight as possible, and I'd like to add that to the 2 colonies that we have right now. The closed colonies should, I feel, have more transparency and oversight in terms of operations, just for consumer protection Anyway, now I know we can't get into rewriting the bills, but I'm just saying both of these bills are a work in progress, I think, right?
Jessica, did you? Yeah, I just wanted to clarify that the jurisdiction would fall under the California Department of Food and Agriculture.
To create the standards and.
Correct.
Right.
And so just to go on further, I think no one I talked to was against developing the community blood banking model. Everybody's fine with that as long as the testing is rigorous and the safety of the blood is ensured. But the concern that I had and many people also had was closing down the closed colonies. If we outlaw those, then we're just not going to be able to meet the volume of blood that we need. Yeah.
So the concern that Kathy just raised would be solved by the second bill, 202, that's going to allow the community blood banks, and it won't do anything to the existing closed colonies.
That's my understanding.
My opinion is that we should focus on 202 and oppose 366.
Well, I've heard that what triggered all this was an investigation from PETA that the animals are in fact not treated very well in the closed colonies. And I hear you about, the shortage of blood, but I also think, we also need to keep the animals' well-being in mind as well. And they get the greyhound dogs, correct? The racing dogs are what are donated to these.
Some facilities have greyhounds, some don't.
Okay. So that's supposed to run out pretty soon because greyhound racing's days are numbered. So I'm just curious, where do they plan to get?
They go to shelter. My
They'll
understanding,
get
they go to
shelter
shelters
animals?
and get animals that otherwise would just be euthanized.
Okay. I'm very concerned about this bill. I feel very uncomfortable voting it down because we shouldn't be having animals in hideous conditions.
But how do we know they're
deplorable
hideous?
conditions.
So can you?
I can speak
we
to,
need to
I can speak to the UC Davis dogs at least, which maybe is different than some of the more commercial, the two commercial places. But I actually have patients that were adopted out from the UC Davis program, and they continue to take care of those dogs as they grow older. So they come to me, and UC Davis takes care of some of the bills. And they're in loving homes. So those dogs have, and at the vet school, they seem very well cared for, and the students take care of them.
But that's not a close colony, is it?
It is a close colony.
It is a close colony?
They have close
It
colonies.
was then.
When I was there, yeah.
How long has it not been a close colony?
I don't know that one.
6 years. 6 years.
I thought 10 or so. But
Somewhere in that.
I mean, I hear what you're saying, and I agree. I obviously really care about the animals' well-being as well. I worry that this is not really, that this is doing so much at once that it's going to actually hurt a lot of animals that need blood. We have a lot of dogs and cats that need blood. I think it's also interesting that this is just about dogs and cats don't matter. But in any case, it's I think the way that they're going about it is going to actually hurt more animals than it's going to help. That's just my opinion.
And so I had heard those rumors too about what had happened down south, but looking into it further, it turns out that largely those were unfounded. And I could fill you in more maybe later, but it's getting into too much detail. And so in trying to investigate what really happened, it seems like those were just really unfounded rumors. And in talking to people about their closed colonies, these dogs seem to live, a decent life. They're very well cared for. I talked to Dr. Ann Hale, who's a veterinarian who's been in the transfusion business, 30 years, and she has a closed colony in Maryland and produces the lyophilized platelets that you were talking about. But she says she takes dogs that that otherwise would be euthanized, that couldn't find a home. They're not adoptable, just because of the way they look, the way they act, probably the combination. And she brings them into the colony, and she hires trainers to come in. They have volunteers that come in and play with them and walk them. But through training and through the interaction with people, they become socialized, and then they're able to be adopted. So otherwise, these dogs would have been euthanized. And if you talk to, when I was at Davis, and they have a community college now, or a community colony now, and besides Dr. Sean Owens, who runs that colony or that community, there were 2 technicians there, and they had been there when you were there and had the colony. And these are the ones that actually worked with the dogs. And she says these dogs they had a good life. It's not just because you're living in a restricted area. I mean, my dogs, if you want to look at it, my dogs are living in my house. And some people would say that's cruel.
Not your house.
Into your house.
So anyway, bottom line is I don't think you should believe the rumors, what you hear about what happened down south.
I think part of the problem here is the troubling state of the law in California and the lack of understanding of what does go on in those closed colonies. And that's where I think there's confusion and concern. And I find I'm still surprised at the special set of circumstances that those 2 colonies are run under, and the lack of transparency about reports and behavior. We had a wonderful tour of the Davis one, and it's nice when you hear from Dr. Hale or Dr. Owens that they check for behavior, make sure the dog's comfortable with even having blood drawn. They're careful in the timing of when they draw the blood. And I just think the problem here is we are not allowed to know exactly what goes on at those colonies for whatever reason. CDFA doesn't report out its findings and things like that. And I think that's where the concern is about. I think there's no question that we need the blood, and we need the blood products, and that vets should be able to import products they can't get here. But the fact that you can only get them from 2 colonies here in California, and those 2 colonies may or may not have issues with behavior and health and welfare of their donor dogs, and we just don't know it.
Does Food and Ag have inspection programs that routinely inspect?
Yes, so CDFA inspects both of the colonies in California.
Okay, I'd like to, I think, open it up to public comment unless
Good afternoon, Chair and members of the board. My name is Jeffrey Leacox. I'm with Greenberg Traurig, and I do represent one of the 2 in the first blood bank licensed in California, Animal Blood Bank, also known as ABRI. If I might, I don't know how much time I have here. I know I could go on longer than you'll give me. And so maybe what I'll do is say my piece and invite some questions, because there's a lot of misinformation and a lot of unclear information even in what I heard today. First, let me say that I've represented Animal Blood Bank since the early 90s. All of the current law, which is in the Food and Ag Code dealing with blood banks, I was there and negotiated the language. I can give you the history of how it turned out that way. But in terms of the state of the law in California, the first thing I would tell you is California is doing it right. It's the only state in the country that regulates the production of animal blood. No other state regulates animal blood production, and the result of that over the last 20-something years is the highest quality and most abundant supply of blood anywhere is here in California. There is an issue about a couple of products, I think both of which my client offers, and their availability. That issue really has to do with one of the unique things about California's program is that all of the blood sold in California by law, at least as interpreted by CDFA, is required to be produced in California. And some of those products undergo a process outside of the state Ironically, that process occurs in an FDA GMP licensed facility used for human medicine. So we're pretty sure of the quality that's coming out of it. But because that's produced outside of the state, at least up until now, that has not been allowed to be sold. Because my client is licensed in the state, they can't take the risk of offering a product and losing the license for everything else that they do. Although I think there is some evidence that things come into the state that aren't produced here. There also is no regulation at the federal level. When my client invented this business many years ago, they reached out to the USDA and were told that the federal government did not consider animal blood a biologic. California, which had a mirror biologics regulation law to the federal law, took the opposite view and said, yes, we are going to regulate it as a biologic. So that's how we ended up where we are today. As to the bill, first, I'll be clear, we encourage you to oppose that bill. But I do want to say right up front that we are supportive of community-sourced blood banking. There is a shortage of blood, and anything that brings high-quality blood to the market that protects the welfare of the animals, we're in favor of. In fact, Animal Blood Bank operates a community-sourced blood bank in Michigan, which is another place that they have facilities. To be clear, none of that blood comes to California. Only their California blood goes to California. But they know what they're talking about with respect to community blood banking, both because they do it and because they support and train community blood banks around the country. And they would be happy to do that here in California. At the same time, I would say that community source blood will never be as safe as what you get now. It will never be the same quality as what you get now from a controlled population. And I think somebody mentioned a particular example where a community-sourced blood bank found that they were transfusing tainted blood. That also happened to the University of Pennsylvania. And the problem there is that you can only test for what you know. You can't test for what you don't know. When you control the population, last year, you're probably more aware than me that there was an outbreak of Asian flu in the canine population. Had you been community sourcing blood in California, in all likelihood, some of that blood would have been transfused before we figured out that the cow got out of the barn. So our view on that is that you've got to test every donation. You have to test the animal every time. That's the best practice that Animal Blood Bank follows in Michigan. Some people will say that's too expensive. I think the facts probably lead otherwise, and keep in mind this is donated blood, so you're not paying for the cost of getting the blood, you're getting that for free. So that's the absolute safest thing you can do. Even if you do that, it's not as good as controlling the population. As far as AB 366 is concerned, I'll just make two more comments. One, the idea that a licensed vet needs to be directly involved in the operation of the bank is both too high a requirement and too low a requirement. It's too high because you don't need to be a licensed vet to do this. Neither of the current blood bank owner-operators in California are California licensed vets. They never have been. It's also too low in the sense that just because you are a licensed vet doesn't mean you know how to run a blood bank. The current law, which is overseen by CDFA, does require oversight by a licensed vet, and that's meant to get at the issues that a vet should be involved in and overseeing, but there's a lot more to it than that. And what we've told folks is it's actually a barrier to community source blood banking if you're going to require that a licensed vet be intimately involved. That comes at a cost, and it's not really necessary. Yes, there needs to be an oversight vet. The other thing I'd point out about AB 366 is it kind of muddies the water because when it talks about community source blood banking, it's putting language into the Business and Professions Code, where this board and the laws that it administers exist, rather than in the Food and Ag Code, which is where the blood bank licensing law is. And that's all regulated and overseen by CDFA. And I guess finally, let me say, just to be clear, CDFA we're completely transparent to the regulator. They're required by law to inspect at least annually. They can come out more often, and the situation that was alluded to earlier about issues here in Southern California are an example of that. My understanding is that there was an exhaustive several-month investigation that followed allegations by Hemopet, or against Hemopet, that there was some 800-page report prepared, and that all of those allegations were found to be unfounded. Now, I don't have access to that report because I don't represent the blood bank that it pertains to. But I think that the committee, I know that the legislative committee that considered the bill did get a summary of that report, and that might be available to the board if you haven't seen it. So I would say, far from any question about whether animals are being treated well at least in our blood bank, and I think based on that report in our competitor's blood bank, the answer is yes, very well. One of the things about the regulation is that they know every animal that enters and exits the program. They get quarterly reports on the blood that's produced by animal. So you can see immediately if an animal is leaving the program, if they're not producing blood, if there's an issue, if they're not there when you come for the next inspection, what happened. So there's a lot of oversight, there's a lot of insight into what's going on with the animal when you're taking their blood, when they're being handled by vet techs. I would dare say they're getting better medical care than every pet, and probably than most humans, because they're just regularly overseen by professionals who know what they do. And I would echo the comments that these are very healthy, happy animals. Sadly, in California, donors don't really come from shelters anymore. And this kind of gets to the point of why records are confidential. It used to be, when Animal Blood Bank started in this, that's where the animals came from. But the animal rights activists have made that untenable for shelters, so they can no longer do that here. We don't ask our friends in the shelters to do that because it brings grief to them, and it's not helpful to us. So in California anyway, I think the greyhound is how our competitor does it, but we're breeding animals because that's the only viable source at this point. And the reason the confidentiality is needed is for just that reason. And I would say that the allegations against our competitor illustrate why that continues to be true today. They were very transparent, and the reward they got for that was unfounded accusations. So, thank you.
Yeah. Sorry. You mentioned that your company that you represent is involved in a community-based blood bank in, I think, Michigan is what you said.
Correct.
How often do they test each donor? Is it tested each draw, or do you test this every 6 months, or how do you do that in Michigan?
For the community source, which means not in the controlled population,
Right.
they're testing every bag, basically. Every donation.
Every donation.
They're-
Every donation.
Yes.
And what is the average cost of that testing? And
it's less than my hourly rate for sure, and I don't know the answer to that. I'm sorry, I don't know
Thank
the
you.
answer.
I'm just curious.
But
Okay.
we've had
Yeah.
this conversation, and I think what I can say, and this is perhaps one of the ways that my client may be able to help community source blood banking in California, is to make that testing available at a cost that it has as a large consumer of testing. But suffice to say, that should not be a barrier, given that the blood is coming free. That should not be a barrier to community source blood banking. The truth is, and I think as consumers you know this, that the market will pay the price needed for the blood.
Any other questions? Yes.
Yeah, just a quick question. When you said the 800-page report, all I could think of was the Mueller report. But anyway, and since that's being issued tomorrow, is there can people get a copy of that full report that was done? Do you know if that's available? I mean, you mentioned a summary, but do you know if that's...
Well,
requesting it. I don't even know legally if you can, but
So what the law says is the records related to the oversight of the blood banks are not public records under the Public Records Act.
Okay.
That being said, I do know that that members of the committee and staff to the Assembly and Senate Ag committees did receive summaries. I don't know whether they received that from the licensee, which obviously is free to share whatever they want, or if they had permission from the licensee. I'm not exactly sure how that happened, but I think if folks are interested in seeing a summary, that is possible.
And can I just as an informational sake, in your closed colony here in California, how often do you draw blood? Is there a period of time? I mean, I assume there's a safe period of time, but
well, so you're talking to a lawyer.
I know I'm talking not to the person that runs it, but do you know
the oversight
how often they draw?
But yes, speaking from the information that I know, it's going to depend on the size of the animal. But let's say we're talking about a 50-pound plus dog. A 50-pound plus dog can give blood every 3 weeks, just like a human can give blood. And I can't speak for our competitor, but I can say that that before every draw at my client, the blood is checked, back cell volume is checked, and if the blood isn't suitable for donation, then no donation is taken. Not only do you skip that cycle, their policy then is to skip the next cycle. That would be 3 weeks later, and then check again in 6 weeks. So there would be some time out, and that's just one way of telling you what the health care is. These animals, it shows up in the blood if they're not healthy, and so they're getting attention right away.
Okay, yeah, I thought I'd read somewhere where someone was testing every 10 to 14 days, and drawing, and that seemed a very short period of time, but as a consumer and a layperson, I didn't know.
If that was a question, and I may be so bold, I've read something similar, and my understanding is our competitor takes a smaller unit more frequently. So maybe it's a half unit on a more frequent schedule, but it's the same idea of, and I understand there's some argument that that producing new blood for the animal is good for the animal, good for the blood, which would be a reason to do that more frequently, but that's way out of my pay grade.
Do you know what the average time serve is for your clients, blood donors?
I can clarify a little bit on that. So with my client originally, and this is explains some of the legacy of what's in the current law on this. We were rescuing animals that would otherwise be euthanized. They were basically non-adoptable animals. My client at the time, who's since left the business, described them as large brown dogs that nobody wanted. And so our concern back in, I think it was 2002, when Sheila Kuehl ran a bill, SB 1345, that was really the first time that there was explicit language dealing with blood banking in California, was that if we had to artificially limit the time an animal could donate, that was basically a death sentence for the animals in our program. And the way our program worked is, think of it more like a racehorsing farm. Animals donate as long as they're physically healthy and able to do that. And because that's generally a long time, the economics of that allow the animals to, be put out to pasture, if you will, and live on even as non-donors, as long as they're having a healthy life as a non-donor. We do have a voluntary adoption program, and so sometimes folks who work in our facilities or otherwise would take an animal out, but for the most part, at this point with the animals that are bred, that's what they're bred into, and that's what they do, and they're very healthy, happy animals. We've actually found that they're probably better adjusted than the shelter animals that we were bringing in before, because this is the life that they know. Dogs are pack animals, and we're not talking about cats here either, but dogs are pack animals, and our facilities are in a rural setting. There's a lot more space. There's a lot more opportunity for the dogs to be in groups. They're sometimes kenneled together, depending on how it works best for the dog.
It's all dogs. There's no cats. There's no cats. It's all dogs.
We also have canine blood that was taken out of the bill. UC Davis does have a colony of cats, and basically there is no viable way to have cats coming in to donate blood.
So your client?
Yes. Oh, yes. Yes.
Okay. So then in your system, those pets that have been retired because they're done, and they're not adopted, do they just live the rest of their lives at the facility?
So if they're not adopted, yes. Yep.
To die of natural deaths?
Well, the alternative is that they would die an unnatural death, and they would be replaced by another healthy animal. So,
but they are allowed to live out the rest of their lives.
That's the practice that we got to. Yes. Yeah. Yeah.
So some are adopted out? I'm sorry.
Yes, some are adopted out.
Is there an active program to try and adopt them out, or is it just if like a worker there wants one of the dogs? Is that kind of what's happening?
It's more like that. That the law doesn't require that, and in most cases, when that law was created, that was not a viable option, and at this point, adopting those animals out means that you have to replace that animal with another animal. And I would just, again, challenge the premise. These are happy animals. They're happy where they are. I have a dog who's home alone right now, and is often home alone during the workday. And so, I think that it's a false premise to suggest that all animals in a home are better off. In fact, these animals are probably better off than many pets. So they're very well cared for, and they're well loved.
Can someone, maybe you can explain to me, in human medicine, we don't use closed colonies to get blood, is that correct? It's all community donated, right? So why do we need closed colonies to get blood in terms of animals?
Well, in the human population, we transfused HIV, we transfused hepatitis C. There were a lot of problems with the human
but we test for
model.
all that now.
We do test for all that now, but again, it's still after the fact. One of the issues with testing and the consensus protocol that's in the legislation is that what you need to test for is in some sense regional, and it also and it's evolving over time. So putting something in statute as a floor doesn't hurt, but it's really not enough, and that's something that's addressed in the protocols and by CDFA in the context of licensing. The reason why you need colonies in animals, I can kind of do some quick math for you. Studies that have been done in the community blood banking model would suggest that you can ask an owner to bring an animal in 3 to 4 times a year. Less than that, they forget. More than that, they say forget it. So if you're talking about every 3 weeks, that's 17 times a year. If you're replacing that with a community model to do 17 times a year, you need 6 times more animals, right? Just to get the every 3 week. I would say that Davis is probably the best example of a community-sourced model. And keep in mind that they're operating under the veterinary exception, and that was a bill
well, that's always been the law, and there was a bill that we worked with CVMA and CDFA last year to clarify that it continued to be the law. Veterinarians can take and use blood in their own practice. They can't sell it unless they're licensed as a blood bank. So anyone right now, any practice, any large practice, small practice, could be doing community blood banking like UC Davis is doing to take and use in their own practice. That's essentially what community blood banks elsewhere in the country are doing. It's a regional, it's small volumes. They cannot meet the need of the modern veterinary practice. There's just no way to produce the blood that's needed to treat all of the animals. So that's the bottom line on it. And our position on the legislation has been, and we're not quite supportive of the other bill yet, but we're a lot closer, is that we're not afraid of the competition, and we're not afraid if folks want to come in and say, hey, you should buy our blood because it comes from happy dogs as opposed to our competitors' blood. We think we can compete both on the happiness of our dogs, also on the quality, but at the end of the day, it's not likely, time will tell, but it's not likely that community source blood banking can replace the demand.
Yeah, if it's okay. Just to answer your question from a personal experience standpoint, so we have a large specialty practice that I work at, and we, when we were feeling like it was still legal to do community banking, we tried very, very long and hard to get people to participate in that, and we had, there's a couple of problems. One is that there are not a lot of A-negative donors, and we can use positive blood sometimes, but ideally we would want to use A-negative blood. So that was one thing that we would run into, but in general we just could not keep up with the demand with just a community sourced donation process. At Colorado State, we had a community-based blood bank, and that was mostly with adopted greyhounds, and we ran out of blood quite frequently there. So I agree. I think that it would be, we just have a huge need for more blood. I think we should be looking at doing both, in my experience, and just for my patients and my clients. So that's
I was going to say about UC Davis, so that's as good as it gets. You've got the finest veterinary school in the world. You've got students with animals that are eager, willing, and happy to bring them in, probably donating blood more often than 3 or 4 times a year. Last year, my understanding is they were able to take 600 units. And my client is not inclined to share its proprietary information, but I'm happy to talk about our competitor. Our competitor, I understand, has 150-something dogs, maybe slightly more. If you use the every 3 weeks, 17 times a year, and you consider that you can take a donation and break it into 4 parts, you can spin it out and press off the plasma and then divide the plasma and the leftover red cells into two bags each. You get 4 bags. They produce somewhere in the neighborhood of 10,000 units a year. UC Davis is not breaking all of their blood up into components. So, but if you want to assume that they did, 600 units would be 2,400. So they're a quarter of the size of what I will say is our smaller competitor. And that's as good as it gets. Maybe it could get better than at Davis, but you know, how is it going to be in Tulare? How is it going to be in Palm Springs? You need lots of animals. You need lots of committed owners that are willing to bring it in. And the history shows that you can get some, but not lots.
I appreciate the comments, and I appreciate you being here. You don't go anywhere. I need to open it up though for other comments. Are there any other comments on AB 366? Because you kind of segued into the 202 bill. Would you care to? Can I allow him to share your opinions on the 202?
I'd be happy to. So, At this point, our position isn't officially recognized by the legislature anymore because we took a concerns position, and under the new regime you have to be supportive or opposing or you don't show up. We are supportive of community blood banking. That's 90% of what SB 202 does. We are working with the author and providing some suggestions on best practices, but our view on that is California is going to do it how they do it, and we will follow best practices whether anyone else does. We're not going to stand in the way of a community source bill if it doesn't meet our standard. The things that we're concerned about, one of the things in that bill was to require the veterinarian oversight rather than the current law, which is oversight by a qualified person. I think both the sponsors, the author, and we agree that that is unnecessary, and I expect that's going to come out of the bill. The biggest concern we have is that bill would create confidentiality for the records related to community source donors, and it would repeal confidentiality for the records related to colony donors. And as I've alluded to previously, that is necessary because, I've been lobbying animal issues for over 20 years now. I've been the subject of death threats. I know others that have. I've had clients that have been firebombed, trespassed, threats, stalked. The folks that we work with in doing our business, we can't subject them to that kind of treatment that's meant to, there are folks that want to put us out of business, and I don't need to impugn the motives of anybody who's involved with the legislation or anybody in particular, but the fact is those people do exist. And if the records aren't confidential, we know what will happen. And so we think that existing law needs to stay as it is. And then there's a kind of a lawyer's point, an and versus an or, that we're still talking about as well.
Yeah. Does the board need some information from Jessica on 202 before we keep going on that, or do you want to go back to 366?
Well, one thing I just wanted to clarify with the witness for a second. I think when you were talking about Davis, I think when we were there, I just wanted to make sure. My understanding is that at the Davis Community Bank, Blood Bank, they could expand their donor pool and produce much more blood. They just do enough for their cases, because if it's left over, it goes to waste because there's nothing they could do about it. But I think that my sense was that they could be more produced in terms of more products, not products produced, but more blood and use more donors there. And all this schools, obviously, they're in an interesting environment. They've got students, they've got faculty, they've got community around, and they seem to be very well adapted. It would take more staff potentially, but they could be producing a lot more, it sounded like.
I think I said as much. It's possible that Davis could produce more. It's still a best case scenario that doesn't exist really anywhere else in the world, much less anywhere else in California. They would be a fraction of what's currently being produced, even if they doubled or tripled or quadrupled. And we will help them do it.
I have another. California currently doesn't allow for community blood donation centers.
You can't sell the blood.
But Davis has a community blood center because they're a university and they use it just for.
Only use it on campus. So other veterinarians can use the same model for their own clients, but they cannot sell it outside of their practice.
That's correct. And in fact, we would say and have said that it's not true that California law requires a colony-based method. It is true that the two licensees are using controlled population. That is the best practice. It is the way to produce the volume that's needed. But the law doesn't say you have to do it that way. The law says you have to submit protocols to CDFA that explain how you're going to comply with the law. And some of those questions are more easily answered. The biggest hurdle is CDFA is required to do an annual inspection. They're required to inspect against the Animal Welfare Act husbandry standards. And it's a fair question of, well, how do you do that for an animal that's in a home? if you're asking me to have my dog donate, and the first thing you tell me is, and when should I schedule the CDFA inspector to come check out your house in your backyard, I'm going to say, no thanks, I'm out. I'm not going to do that. While it may be possible to address that through the protocols, what we've said is if we need to clear a path to deal with that issue. But what we've also said is that you shouldn't have no regulation. You shouldn't have no protection for the welfare of the animal. What the two bills do right now is they say, well, let's trust the vet. It'll be fine. It's done under the control of a vet. Well, we have 3 vets. We have an oversight vet for every one of our facilities. Animal Blood Bank employs a vet full-time that oversees their oversight vets. And the state veterinarian is ultimately the inspector of our program. So if trusting vets is enough, why are we being inspected for husbandry? It's not enough. You do need to do something. It's not exactly clear what it is you need to do, but you should do something.
So I think the board at this point needs to discuss a stand on AB 366.
I motion to oppose 366.
I second.
Any further discussion of the board? Any further discussion from the public? Call for the roll.
Ms. Bowler.
I'm always wary about all this legislation because it's likely to be amended and changed. And so right now I don't know what's going on with this legislation, but I'm going to abstain from, or I would opposing right now. So whatever you opposing.
So are you voting no on oppose, or are you abstaining?
Yeah, let's say no on oppose.
Okay. Dr. Bradbury.
Yes.
Ms. Laredo.
Abstain.
Dr. Nunez.
Yes.
Dr. Waterhouse.
Yes.
Ms. Yanis.
No.
Dr. Noland.
Yes.
So the motion carries.
Can I also motion to support 202?
Can I?
Sure, we want to take that one next.
I'm sorry. Can you explain that one? Just
Yeah,
we never
we need
had
to
your
talk more
explanation.
about 202.
Yeah. So 202 also it relates to blood banks, but it instead of eliminating the closed colony model, it allows for the community blood bank, and it also makes more transparent the closed colony records as it relates to public records, and that's essentially all it is doing at this time.
Thank you. I'll second.
Jessica, on AB 202 or SB 202, that does not have a phase out at any time if there's a trigger.
Correct.
Community colonies starting to do really well and the blood supply being fine. It still allows the closed colonies, the 2 in California. Okay, and it increases oversight on those colonies as well as the communities.
I don't think it increases oversight. It allows the community blood bank model to exist in California.
Okay, I thought it had was hoping it had something additional for oversight of the of all community and the closed colony.
I might have missed that.
I think didn't you say it allowed for more transparency?
Yeah.
The bill would delete the above described exemption from the California Public Records Act. So right now the closed colonies are exempted from the California Public Records Act except for personal information of owners of community-sourced animal donors. So they would then get an exemption.
And I think that gives everybody a better idea of what's happening in those closed colonies.
Yeah, it says all the oversight still applies, but you're just adding these community-sourced colonies. So all the things that apply to the closed colonies would apply to the community colleges, as far as oversight from the CDFA, testing requirements, and all that. I heard the only thing that was of concern to the person who just testified was something about this bill requiring veterinary oversight. But I'm not sure what he's referring to there. And then something about confidentiality of records.
So I can read that portion of it. It's under 9212, produce animal blood and blood component products under the direct supervision of a licensed veterinarian. Again, this is just the current text, and it could be modified or amended.
It may be the source of confusion. SB 202 was recently amended, and so some of the changes that were in the bill as introduced now appear to be existing law because the recent amendments changed them from italicized to regular typeface. So the amendment that the President just described was a change. Existing law says you have to operate under the direct supervision of a qualified person, and SB 202 would change that to licensed vet. And there were two other changes. The most significant and the one we're most concerned about is the confidentiality provision. We also think that that the community blood banking part of it isn't quite soup yet. So I'm not sure. I'd encourage you to support the bill, but I sure wouldn't encourage you to oppose it.
Can I ask you one more question?
Oh, absolutely.
Would you be amenable to having a portion of your records and information public and keeping certain things, for instance, your address and location, private? Is that something that, have you thought of?
I'd rather negotiate the bill with the author.
Yeah. I'm just curious of your what your opinions are.
Well, I think, speaking in the most broad sense, I think it's a fair criticism that right now the public doesn't know if CDFA is doing its job. I can tell you they are, but the public doesn't know it because you can't see it. So the law says they have to inspect at least annually. The law says that they have to inspect against certain criteria that are in the statute. They show up with a very extensive checklist and they go through and they inspect and they do the job they're doing. But one of I think the fair criticisms is how do you know that? How do we know the government's doing its job? And so is it fair, in other contexts, is it fair to report that the license exists, that it's in good standing, and if there are any issues, we could talk about that, but I would say the focus there is, are we making sure that CDFA is doing its job? We're not inviting folks to second guess CDFA and what they're doing. And some of the advocates for the two bills would like to stand in the shoes of CDFA, and we have grave concern about that.
Yeah, thank you. Other questions or Tara?
I just wanted to point out that Section 6, which would be 9269, Subdivision A, talks about this is the CDFA change for the records moving from confidential to public, and it's broader than even this board because applications, fees, or inspections would be publicly disclosable, and this board does not make inspection records disclosable, which protects not only the consumer but also the practitioner who might be challenging false accusations. So we protect both parties until the board has determined that there was in fact a violation. So that is broader than what we're subject to. But I did notice that in Subdivision B, information related to the guardian of a community-sourced animal donor, the person's name, address, and phone number would be confidential and withheld under the CPRA.
And to clarify too, the bill was amended on April 10th, I believe. All references to guardian has been changed to owner.
You made the argument better than I could have. Yeah.
And I agree with that concern about the exemption for, or deleting the exemption for the confidentiality of records. I think it is important to keep the records confidential for the reasons stated. I always hate to assume how these regulations are going to be used, but I assume that the community colonies are going to be run by referral hospitals, bigger hospitals. And in that situation, having a veterinary oversight probably wouldn't be difficult because there's plenty of veterinarians there. And I think it is kind of important because the more people that are collecting blood now, because we need more blood, the more potential for there to be issues. And so I would be in favor of, if you're going to expand the production, raise the level of supervision to make sure that things stay as they should.
Madam Chair, if I may, SB 202 would leave in place the requirement that every licensee have an oversight vet. So we currently have that, and that wouldn't go away. It would add that not only do you have to have an oversight vet, you have to have basically somebody whose full-time job is to do that, which I'm not even sure is what you're describing. You need somebody to run the blood bank, and that person doesn't need to be the vet, and they do need to be qualified, and a vet isn't necessarily qualified to do it. So you're not losing vet oversight. It's like saying that I don't have a good analogy, so I won't even try. But it's too much. You don't need the vet to do the COO job. You need the vet to sign off on practices and treatment of the animals and the medical part of it. Yeah.
I'm sorry, I have another question. I guess I'm not sure. Does this increase our ability to get blood, or is it just because I think what I'm hearing is we can do community blood collections at this time, but we just can't sell it. And so if we really need blood, we can do that, but we can't have our own blood bank. And this is allowing us to have a blood bank at our own hospital, but it has all these other requirements. I'm just unclear as to exactly what this is going to, is this really going to improve our situation, or is it going to make it more difficult? Like to have an actual community based, is it going to make that more difficult for us the way it's written? I guess that's my concern.
I'll jump in there, but I think the two issues that we're talking about that will be different than what we have now is the direct supervision of a veterinarian and the exposure of the non-confidentiality of the closed banks. Am I correct with that, Tara? I would lean on you. But we already have the ability to have veterinary run open community blood banks.
Well, I think that is true, but I understood your question to be whether or not it's, opening up the doors for other sources of blood. And I think it looks like that is true under Section 9205. It expands the definition of commercial blood bank for animals to include captive, closed colony, or community-sourced animals to market and sell for use the blood and blood products.
Okay.
Okay. Yeah.
Thank you.
And it'll allow selling.
But thank you.
So we probably need to keep moving.
Yeah, I was just going to say, this does not still allow California vets to import products from out of state. So we're still in that boat about the few unique products that we would like to be able to have, and that you're substituting human blood for. Okay.
Okay, any other public comment? Any motions from the board? Are we ready to?
I had made a motion to support.
Oh, I'm sorry, I forgot.
I'll second that.
Any further
Sorry,
discussion?
I didn't hear that. What was the motion?
I guess there was an initial motion to support and it was seconded by, it's been a while ago, I forgot.
All right.
Any more public comment?
Okay. Ms. Bowler?
I was just going to say on the support, I had one quick question on the bill itself when looking at the analysis. Who are the supporters of SB 202 just has the one committee on social compassion or whatever. Are there other notable supporters of ABS? CVMA is not taking a position, is that correct? Oh, you have taken a position.
With the removal of the word guardian, we have a support position on the bill. I attended the hearing on 202, and the two veterinarians that spoke in support of it represented social compassion and legislation and PETA, and they are the sponsors of the bill.
Okay.
The analysis also mentions 164 individuals who have supported the bill. Okay. Ms. Bowler?
Well, I mean, I support this bill, but it doesn't go far enough. I wish it had a lot more content to it. I mean, I'm still not thrilled about this bill. Is my way around saying.
We should put you at the end of the roll call.
Yeah, put me at the end. Pretend Bowler was a Z, Zoller. So go next. I'll pass for a moment.
Dr. Bradbury?
Yes.
Ms. Laredo?
Yes.
Dr. Nunez?
Yes.
Dr. Waterhouse?
Yes.
Ms. Yanis?
Yes.
Dr. Nolan?
Yes.
Ms. Zoller?
Oh, okay, now we're to me again.
Okay. Ms. Bowler?
Yes, no. I mean, yes, I support this one, but would rather see it written better.
All right, motion carries.
Can I just add that again? That's true.
Okay, it'd be 496. We're taking a break. One more. We're doing one more.
Okay. Well, 496 should be fairly quick. Right now it's just making non-substantive gender replacement terms and various other non-substantive changes. It has moved through since this memo. There was two analyses done, one on Assembly BMP, one on Assembly 4. But again, there's very little to this bill right now. I anticipate this changing. It very well could be the Omni bill that will be added through it, but right now it's very non-substantive. So the board may want to just watch this as it goes through.
I motion to just watch.
Second.
Okay, we have a motion to watch, a second. Any comments by the board?
I do have a comment on that. Isn't this going to make more work for you? Because it says existing law authorizes the director to audit and review complaints regarding disciplinary cases, either on your own initiative or at the direction of a request. But then it's saying that it's going to require you to report to these chairpersons.
It's requiring the director to report.
Of DCA.
Yeah.
Okay, so it's not going to create more work for you. Okay, then let's just watch it.
Any comments by the public? Okay, call for the vote.
I'm so sorry, I didn't get who seconded.
I didn't. Is that Bradbury?
Yeah, Dr. Bradbury and then Dr. Waterhouse.
I have another comment. It's going to replace gendered terms with non-gendered terms.
Correct.
For the whole California code, everything.
They're moving in that direction.
Yes. Any public comment?
We already asked.
Oh, sorry.
Yeah, calling for the vote.
Yes. Oh, sorry. Ms. Bowler?
Yes.
Yes.
Dr. Bradbury,
Yes.
Ms. Laredo,
Yes.
Dr. Nunez,
Yes.
Dr. Waterhouse,
Yes.
Ms. Yanis, Dr. Nolan.
Yes.
Motion carries.
Okay, AB 611.
AB 611 should also, I would think, go fairly quickly. It basically makes it instead of it making it criminal for certain animals, it's now for sexual abuse. It's going to be a misdemeanor for all animals. So it is now with the Senate. It's passed through the Assembly. There was analysis added by appropriations, Assembly appropriations. As they say, it's unknown, but it's likely it's minor and unabsorbable. And right now, it's with the Senate Rules Committee for assignment.
My question was that the wait, give me a second. Go to somebody else.
Any comments before a motion or a motion?
I was going to move to support it.
Okay, thank you. A second?
I'll second.
Okay, discussion? Anybody from the public at this point?
Thought it was done. Valerie Fenstermaker, CVMA. Just a real quick clarification in 286.5A, where it says the section does not apply to any lawful and accepted practice related to veterinary medicine performed by a licensed veterinarian or a certified veterinary technician under the guidance of a licensed veterinarian. Just seemed like odd language to us because we just see registered veterinary technician in the Practice Act everywhere, even though I know they're certified. And under the guidance of a licensed veterinarian, it's normally supervision. It's just very technical, and I didn't know if you wanted to bring it up at some point, but we have an approved position.
You could do a support if amended, or just a support and offer that clarification.
Well, offer to the author? Is that what we
Just the clarification.
The second one, what do I say?
We can just stay with the support, and in our support letter, I can provide that clarification.
Perfect.
I have no issues.
Call for the vote then.
Ms. Bowler.
Aye.
Dr. Bradbury.
Yes.
Ms. Laredo.
Yes.
Dr. Nunez.
Yes.
Dr. Waterhouse.
Yes.
Ms. Yanis.
Yes.
Dr. Noland.
Yes.
All right. Motion carries.
One more, 613.
Okay. Okay, 613. This is Assemblymember Lowe's bill. This is related to professions and vocations for regulatory fees. The idea is to allow the board to make minor incremental changes in the fees without going through the entire rulemaking process. The concern is that a lot of times boards, because the process is so cumbersome, we're waiting until the funds are no longer supporting boards, and it also leads to a much bigger jump, a significant jump for the licensees as well. So this would allow the boards to be able to raise it incrementally, no more than what CPI and the consumer CPI. I don't know what that stands for. Consumer Price Index. Sorry, I'm blanking. That's the whole intent of this bill.
Yes.
So does that mean increase it up to the statutory limit, or we
Correct.
can go above the statutory limit?
No, we could not.
Okay.
It'd be a revolution on our hands.
Anyone want to entertain a motion before we discuss, or are you not ready?
Motion to support.
Okay, Dr.
Second.
Ms. Bowler, second. So discussion by the board? Any discussion from the public? Oh, wait, Tara, yes, sorry.
I just wanted to point out that the bill does limit the increase to only once every 4 years. So that might be a concern at some point. If you realize, you go through the whole audit process, you've got your report prepared, you go to the legislature and request an increase, and then 2 years later you realize that your new permit structure isn't bringing in the same amount or as much money as you expected it to, you would not be able to ask for an additional increase until after 4 years.
So I don't think it doesn't remove the ability for the board then to go through the regular rulemaking process to increase it if we need to. I think this provides the mechanism every 4 years if we haven't raised it to do that.
Are we sure? For sure. I am concerned with the language. It starts out Business and Professions Code 101.1 Subdivision A. It says notwithstanding any other law. So this is it. No more than once every 4 years, any board listed may increase any fee authorized to be imposed by that board, not to exceed the increase in CCPI. I'm just pointing it out. I'm not saying it's necessarily a bad thing, but you would have to kind of expect this stuff in advance.
So perhaps a support if amended, because I do know from the author's office that was not the intent to remove the ability to go through the rulemaking process. This was just to streamline the process. So
that's what I understand. So, are you willing to support if amended?
Yeah, are we going to stipulate how we want it amended? Or
we probably should. Just to clarify that this does not eliminate the opportunity to go through fee increase via statutory means. Who was our second? Are you okay with that?
Yeah.
Okay, so we have a motion and a second. Discussion by the board. More discussion. Public comment. Okay, call for the roll.
Ms. Bowler.
Aye.
Dr. Bradbury?
Yes.
Ms. Laredo?
Yes.
Dr. Nunez?
Yes.
Dr. Waterhouse?
Yes.
Ms. Yanis?
Yes.
Dr. Nolan?
Yes.
Motion carries.
Okay, I think we'll take a 10-minute break and then we'll come back.
It'll be for declawing.